This is Dr. Perry Carpenter. I want to thank you for taking the time to join me on this super extra special apportionment master's super class on a Saturday morning. I have a real treat for you today. I want you to know that nothing like this has ever been done before. And if you are anything like me, you'll agree that we can go to QME continuing education seminars and we can sit through 6 hours where the speaker goes through a variety of topics over the course of 6 hours. And if the speaker even touches on apportionment, we're lucky to get 30 minutes of apportionment, 45 minutes of apportionment. Well, today we have 3 full hours of apportionment from the leading apportionment educator in the industry as we speak. And then at the end, we're going to do something that's never been done before. We're going to take the philosophy that Mr. Corrillo is going to share with us. We're going to take his philosophy and we're going to apply it practically to the pages of our report. It's very, very interesting. Sometimes when you go to QME continuing education seminars, apportionment speakers will tell us, and frequently these are apportionment speakers like applicant attorneys and defense attorneys, and they'll tell us, they'll say what you need to say and what you need to do. And what you need to say in your apportionment section of your report is you need to say, and they're experts at telling us what we need to say. But then when it comes time, or when you ask them, well, how would I do that? How would I say that? Can you show me? Can you show me how you actually would write this up in the body of your report? And that's where the conversation goes silent. And many of these applicant attorneys who want us to do certain things and the defense attorneys who want us to do certain things have never actually done it themselves. They've never written an apportionment argument themselves. And it's a different mental muscle, taking the idea of what you think you know you should say and actually putting that on paper in a form that the argument or the discussion constitutes substantial medical evidence. So today we're going to bridge philosophy from Mr. Corrillo, and he's going to blow your mind with the philosophy. And then I'm going to come on and I'm going to show you how to write this up in the body of your report. And this has never been done anywhere before. So I'm so excited to be here, and I'm so excited that you're here. So I'm going to do a screen share here, and we're going to get started. We have just a little bit of admin to go through. So let me bring up my screen. And Mr. Corrillo, are you seeing my screen?
Yeah.
Okay, so just a little bit of admin here. So let's begin. Let me introduce myself. Most of you know me. For those of you that don't know me, my name is Perry Carpenter. I've been at QME for 28 years. I'm the president of a QME management company for chiropractors, California Chiropractic Evaluators. I'm a continuing education provider for the Division of Workers' Compensation. I've written hundreds and hundreds of hours of continuing education for the DWC. I'm also a continuing education provider for the state bar. And you may not know this, but like the medical profession, where we have all these various specialties, such as internal medicine specialists, pulmonologists, neurologists, etc., attorneys have specializations also. And one of the specialty fields for attorneys is a specialty in workers' compensation law. So I'm a continuing education provider for attorneys who are workers' compensation legal specialists. They need continuing education credits, and I provide those continuing education credits for them. So that's about me. Our special guest speaker today, Mr. Ray Corrillo. We're so happy and fortunate to have him here with us. Mr. Corrillo is a retired workers' compensation judge from Santa Monica and Marina del Rey. These were his court areas of jurisdiction. In 2013, he was named Defense Attorney of the Year. And if you've been with us on our Zoomers over the years, this is our second Defense Attorney of the Year that we've had on our Zoomers. This is a very, very high accolade. I mean, you don't know how many defense attorneys there are, so this is a very singular accolade, and he received it in 2013. I didn't know this, but I just learned this. I know that he's an expert on apportionment, but I did not know that he's also an expert on sports law. And I don't know if you've ever had a case or heard of any cases that deal with professional athletes and all of the issues, the complicated issues that are involved with dealing with those workers' compensation cases. He's an expert on that, and he's written case law summaries, and so he has a couple of different areas of specialization. He's also an apportionment educator to judges, attorneys, claims professionals. And I know that leading up to today's presentation, he's just gone through a whirlwind tour of speaking to hundreds and hundreds of claims professionals, including all of the attorneys throughout the state fund, state compensation insurance fund, defense pool. So he's very, very well known. And I first met him, I'll just say a couple more words. I first met him at the recent DWC educational conference. He had 2 sessions, each 2 hours. I went to both. And he was fascinating. It was fascinating. I got in my seat and he started talking. And after about 10 minutes, I was just in QME la la land. The way he speaks about apportionment and the way he lays the foundational principles facilitated, at least speaking for myself, facilitated my understanding of all these complex issues that I've been grappling with over the years. And I'm sure you'll have the same type of revelation as well when you hear him speak. So we're very happy and fortunate to have him here today. So before he speaks, I'd like to have everyone just join me in giving Mr. Carrillo a virtual thank you and a virtual round of applause, please. Thank you very much.
Thank you very much.
Okay, Mr. Carrillo, I'm going to switch screens, and then you can take the microphone, and we'll let you have it.
All right. So first slide. Okay, the next slide.
Okay.
Here we go. Anyway, before we get to what's on the first slide there, thanks very much for that introduction. And about the sports case outline, if any of you who do sports cases, what it is workers' comp sports cases, and it's quite a complex area. I have a 300-page case law outline. I keep it up, same as I do with the apportionment outline, twice a year. You can find it on the Perlman, Brown, and Wax website, our firm website, under educational materials, and you'll also be able to get all my prior case law summaries in apportionment and sports case law if you're interested in that. So again, the materials we're referring to today, or I'm going to be using today, are the PowerPoint somewhat, and also the apportionment case law outline. I'll try and reference the pages on certain cases that we're going to talk about, or certain concepts in the case law update. So when I say the update, the case law update, they're interchangeable when I refer to that. So I understand today that 95 or 99% of all the people attending today are medical legal evaluators and maybe one attorney, if I'm not mistaken. So I've really focused this presentation for medical legal evaluators, and I have other ones that are focused for defense attorneys and claims professionals. They're a little bit different than the one I'm giving today, just to let you know. I also want to let you know there's a caveat here that about 95% of all the cases and concepts we're going to be talking about today do not relate to safety member cases. That has its own area of apportionment or non-apportionment because it has the anti-attribution statutes in which you have the presumptive, certain presumptions that go with certain types of injuries, back, duty belt cases, heart cases, etc. And there's no 4663 apportionment related to most of those conditions. And there's still some that are not within those parameters that you can still get apportionment on, but that's a whole other area that we could spend an hour and a half on with safety member cases. So I don't deal with that for the most part in my materials. So I want to start off with just basically a simple, I know I need to correct something first of all. Dr. Carpenter keeps referring to my philosophy. I don't have a philosophy about apportionment. What I do have is that I believe, and that's why we're going to spend almost the first hour today, that I believe, and this is what my philosophy is, is that you really can't understand all the cases. There's no sense talking about apportionment cases, about Lynn and Hakita and Escobedo, unless you have a very strong foundation in the legal principles, standards, and concepts that all of these cases are based on. If you understand and you can have a working knowledge of the controlling legal principles standards, because look, this apportionment is based on statutes, right? So statutes have a legislative intent, and there's a legislative history to all of this. What was it designed to do? So when you refer to my philosophy, really what it encompasses is these legal principles, standards, and concepts, which again, I don't believe anybody in the state who tries to train medical legal evaluators goes into. They just skip right to the cases and Escobedo and assume that people somehow by osmosis or some other method understand the concepts, legal principles, and standards. And I say the same for attorneys. So in a way, I want to let you know I'm an equal opportunist when it comes to what I think. I think you can never know enough about apportionment. I don't care if you're a WCAB commissioner, a judge, a defense or applicant's attorney, a medical legal evaluator, whether you're an AME or QME, a treating physician. You can never know enough about apportionment. You may think you know a lot about apportionment. I'm so sure some of you do. But I'm learning stuff all the time. Every time I prepare for one of these presentations, I've done hundreds of them, I either have a deeper appreciation for apportionment or I learn something new that I didn't think about before. An example is as Dr. Carpenter said, I just finished lecturing or teaching all the SCIF attorneys in the state. I think it was 200 for Southern California and 100 for Northern California. And when I was preparing for that, because there's a new line of cases that just came out on vocational apportionment, in the Nunez case, which I may have time or not to touch on. But in any event, all of a sudden in myself, I'd never seen the thread that ties all of these cases together, just like all of a sudden hit me just a few weeks ago about what the common thread is that joins Hakita, Escobedo, Lynn, and all these Nunez cases. And all of a sudden I saw, and it has to do with these legal standards and principles that we're going to talk about. And when you understand them, you'll see how it crosses over into each one of these cases, these legal standards and principles, and it's like a mosaic and a tapestry of sorts. So again, being an equal opportunist, I know they're all med legal evaluators today. I'm very hard on defense attorneys and judges and a number of other people in the system who I believe don't understand apportionment very well. Let me give you an example that doesn't involve medical legal evaluators. So I was training most of the work comp judges in the state several years ago, trying to train them on apportionment. And so I was trying to give them a graphic example at the beginning of the presentation to get their attention about that all judges don't know apportionment very well and sometimes not much at all, if you can believe it or not. So I took an example of a recent case that had come out from a colleague of mine who was sitting in the audience. I didn't use his name. And the case involved 4 different apportionment issues, 4663, 4664, Benson, and a prior award, I think. So the judge rendered his opinion and went up on appeal, and the board reversed him and annulled his decision and just said and sent it back because the judge had missed every single 0 for 4. In baseball, that's not a very good day. Right. But if you're a judge, it's a really bad day when you have 4 issues in front of you on one subject, apportionment, and you get all of them wrong. So just to put this in perspective, during the break of that training session, he came up to me and said, "Ray, thanks so much for not mentioning my name." And I said, "Yeah, no problem. I just wanted to use an example to get the judge's attention that some of them think they know everything about apportionment and they don't." Lo and behold, 3 months after that presentation, I see another case come down from that same judge, 0 for 3. Lo and behold, I see recently 4 cases from the same judge. Now, this is several years later from that presentation where he's getting reversed and remanded again, 0 for 4, 0 for 3 in cases in the last 6 months of not getting his apportionment analysis right on 4663, 4664, and Benson. So I'm trying to tell you that if a judge who's supposed to apply the law and understand it doesn't understand it very well, then I can say the same about some medical legal evaluators, some commissioners, and some defense attorneys and claims people. So that's what I'm trying to bring is this perspective that you can never know enough about apportionment, especially the controlling legal concepts, principles, and standards. Now, I know, you say, why is apportionment such an important topic in workers' compensation? I'm just going to give you an example. Most of you, I don't know if you know what an en banc decision is. An en banc decision, which was just issued by the WCAB and the Nunes dealing with vocational apportionment, actually they issued two, is a decision from the WCAB where all the commissioners get together, and it's a unanimous decision, and it's binding on every WCAB judge in the state. That it's not like a panel decision, which is not binding on any particular judge. But once the board issues an en banc decision, it's binding on every single judge in the state. Let me just tell you that there's been no other area of workers' compensation, none, where the WCAB in the shortest period of time has issued as many en banc decisions. If you go back historically and look from April 2005 to April 2006, you will see 6 en banc decisions from the WCAB dealing with apportionment during that time. Now, that was a time when the law had just been enacted, and the board was trying to give the practitioners and people in the work comp community, med legal evaluators, some guidance about what, quote, the new law meant at that time. But there's been no other area of workers' compensation where you had that many en banc decisions on one issue. The other example I'm going to give you, or actually a trio of examples, is that there is no other area of workers' compensation that can have the greatest impact on the value of a case, up or down, than apportionment. I mean, up or down. I mean, most med legal evaluators never see what dollar impact their apportionment determination has on the value of a case. So you just make your, you do your impairment and you do your apportionment analysis and discussion, and you never, for the most part, see the end result of what happened. What did the applicant get? Was your apportionment opinion found valid or not, whatever happens to be. So let me give you a quick trio of cases to set the stage here before we get into the concepts, principles, and standards. So we have the Wagner case, which is one of my favorite cases in the sense that until I read this case, even though I was still a judge at that time, I didn't really understand what an impact this new law would have back in 2004 when it was enacted. So in 2007, 3 years after the new law was enacted, this Wagner case comes out, and it's a writ denied case, by the way, from the Court of Appeal. So Wagner, you had a 100% permanent total disability case, and the WCAB and the Court of Appeal affirmed valid non-industrial apportionment of 99% PD. Let me state that again. 100% permanent total disability. The applicable apportionment ended up being 99%, so the applicant's award was reduced to 1%. No one had ever conceived that this new law could, have that kind of impact on an applicant's case to reducing 100% to 1%. So let's do another case real quick of the trio. These are all 100% cases, by the way. We have a 2011 case, LaRue. It's my 2011 outline. If you're interested, you can find the 2011 outline on the Perlman, Brown, and Wax website. So in this case, the WCJ awarded the applicant 100% permanent total disability. No apportionment whatsoever from the judge. It goes up on appeal, and the board found 70% non-industrial valid apportionment, which reduced the applicant's case from 100% down to 30%. Now, what's important about this case, and we're going to get to it when we get to the Lynn case, the apportionment in that case was based on the following: a pre-existing asymptomatic degenerative scoliosis in the applicant's lumbar and thoracic spine. We're going to talk about underlying pathology, whether symptomatic or asymptomatic, after the first hour when we talk about the Lynn case, but you can see there, and you'll understand in a few minutes, why the Labor Code section 4663 and 4664 was such a radical and diametrical change on the law that had existed for 36 years before 2004, that you could apportion to an underlying asymptomatic degenerative scoliosis that the applicant had. The last case I want to talk about for a second as an example is the Brasino case. It's my 2013 outline. Applicant's QME had the applicant 100% permanently total disabled, no apportionment. AME also 100% permanently total disabled, but with 90% valid apportionment affirmed on appeal. So a 100% case becomes a 10% case. So I hope you get some sense about the dramatic impact. Now, I haven't translated those into dollars, If you want to know what the impact is in dollars in a certain case, let's talk about the Fitzpatrick case, which is a very famous case litigated by Skiff a few years ago. The difference in that case was between whether the applicant was going to get 99% PD or 100% permanent total disability. I can guarantee you, because most lawyers don't even know the dollar figure between 90. What's the difference between a case that's worth 99% and 100%? That's 1% apportionment. 1%, $1 million. $1 million in a case for 1% of the apportionment off of the 100%. So the Skiff was willing to stipulate, but the applicant wouldn't take the 99%. It ended up that Skiff took it all the way up to the Court of Appeal, and in Fitzpatrick, it's on different issues. Apportionment is one of them, but the major issue is how you calculate permanent disability in a certain scenario. So in that case, so you can see that anytime really when you're over a life pension case, and we've heard of life pension cases, anything over 70% PD, the dollar value of those cases goes up exponentially as opposed to cases under 70% permanent disability. So I wanted to have you have some sense of the dollars that are involved when we talk about 10% apportionment, 20% non-industrial, et cetera, okay? The other issue, now those, I gave 3 examples where the applicants prevail, the defense prevailed on proving up valid legal non-industrial apportionment, but they fail a lot, and for good reason. And I think the medical legal evaluators find no apportionment, in many situations, that's the correct determination. But in many situations, it's really the defense attorneys and the carrier's fault because they haven't met their burden of proof. It's always the defense burden of proof to prove non-industrial apportionment. It's not the applicant's burden. So when they fail in their burden of proof, it means that the report doesn't constitute substantial medical evidence. And most of that time, most of the times that is true is based on the fact that the defendant has not either requested supplemental reports from the reporting medical legal evaluator or has not deposed the medical legal evaluator. Or even if they do, the medical legal evaluator doesn't know enough about apportionment to render an opinion on apportionment. I have a case, I think it's on a Benson issue where the reporting physician in that case issued 6 reports, was deposed 2 times, and could not allocate the applicant's PD between multiple separate successive injuries. And the board got so frustrated that they remanded it back and said, you got to pick another doctor to report in this case because either agree to another AME or for the judge to appoint a regular physician under 5701 to try that understands apportionment. So let's get into the concepts and principles. By the way, I just want to mention, as all of you should know, the applicant's bar has come up with a number of tactics, and justifiably so, to try and offset the impact apportionment can have on an applicant's case. You all know Kite, whether to add or combine impairments, Almaraz Guzman, rebutting a strict AMA guides rating. Vocational apportionment was viable for a few years, but now not at all, since the Nunez en banc decision just issued in the last few months. And then you had Hikita for a while, which was also viable until it was limited by the Court of Appeal in the Justice case. So let's get into the basic legal concepts and principles. By the way, if you want to go over anything I'm touching on right now, please read the first 10 pages of my apportionment case law outline, which is an overview of what I'm talking about today in these basic legal principles, concepts, and standards. Again, pages 1 through 10, or 3 through 11, if you take off the table of contents. So what we start with is this. The basic concept of apportionment is what are all of the industrial and non-industrial contributing causal factors of an applicant's permanent disability related to every body part, condition, or system at issue in the case. That would include prior and subsequent industrial and non-industrial injuries, and most importantly, attributable to non-industrial contributing causal factors The most radical aspect of this law is not about apportionment to prior and subsequent injuries. It's about apportionment based on contributing causal factors, which are not necessarily an injury. And you'll see that when we start getting into it a little bit deeper in a few minutes. And that can be the non-industrial contributing causal factors can be pathology and pre-existing asymptomatic conditions, among many other factors. Hang on for a second. So, okay, we have one major leading case in apportionment that came from the Supreme Court. Most of you may have heard. I know you've all heard of Escobedo. Some people have never heard of the Brody case. Now, the Brody case is from the California Supreme Court, and it's I think pre-Escobedo or post-Escobedo. But this characterizes apportionment, and this is from the Supreme Court. The new approach to apportionment is to look at the current disability and parcel out all of its causative sources, non-industrial, prior industrial, current industrial, and decide the amount directly caused by the current industrial source. That means the current industrial injury or injuries. This approach requires thorough consideration of past injuries, not disregard for them. So, I'm going to also, from a recent case, try and give you what I call a 1 or 2 paragraph overview of the concepts and legal principles. Apportionment is the process utilized to separate permanent disability caused by an industrial injury from the disability attributable to other industrial injuries or to non-industrial factors. Now, I'm taking this right out of a case. Listen to this part very carefully, because this is the underlying legislative intent of Labor Code Section 4663 and 4664. Employers must compensate injured workers only for the portion of permanent disability attributable to the current industrial injury, not for the portion attributable to previous injuries or non-industrial factors. What does that mean? I assume that some of you who are listening today are employers, right? So break this down simply. So if your employee has an injury, what 4663 and 4664 say is you as an employer are only responsible for the permanent disability that was caused by the current injury that applicant had working for you, not for prior or subsequent industrial or non-industrial injuries, and most importantly, not for contributing causal factors that pre-existed that the applicant had before they were your employee. So, to constitute substantial evidence as to the issue of apportionment, the medical opinion must disclose the reporting physician's familiarity, listen to this carefully, with the concepts of apportionment. This is what we're talking about right now. The rest of it, in those QME classes that you go to, they talk about the rest of it. Oh, you must identify the approximate percentage of PD due to the direct results of the injury, et cetera, et cetera. That's all Escobedo talk. But the first one, the concepts of apportionment, is what all of that is based on, the concepts, principles, and standards. When a medical legal evaluator writes a medical legal report, and in it has their apportionment discussion and analysis, what it usually gets when it goes up to, say the case doesn't settle, it goes to trial. So the judge has to determine whether that medical opinion on apportionment constitutes substantial medical evidence. And to do so, the judge is supposed to determine whether that doctor's report not only meets the Escobedo standards, but also reflects the correct application of the underlying legal principles, concepts, and standards that all of those cases are based on, Escobedo, et cetera. So that's what I'm trying to impress on you today, and what we're going to spend a little bit more time giving you examples about these underlying legal principles and standards. And by the way, I do have my alarm set for of this 2-hour presentation. That's my segment for about 15 minutes of questions, 15 or 20 minutes of questions. So you'll have plenty of time before the 2-hour session is over to ask any questions you have. So let's start with the language itself of the statute. Labor Code Section 4663 does not limit the types of other factors. Remember, I talked about injuries, right? That's the simple part about apportionment. Prior or subsequent injuries, but we're talking about contributing causal factors. The language of Labor Code Section 4663 does not limit the types of other factors that may be considered as non-industrial causes of permanent disability. So this is where I think people have their knowledge base expanded about contributing causal factors when I get to this particular part of this section. So hang on. Oh. Okay, let's talk about contributing causal factors in real life examples. Is morbid exogenous obesity an injury? If anybody out there thinks morbid exogenous obesity is an injury, raise your hand. It is not an injury for purposes of workers' compensation, not define it as an injury. It can be an underlying condition or factor. Morbidly obese has this condition, which can or may or may not, depending on the type of injury, may be a contributing causal factor of an applicant's permanent disability. So you'll have cases. You'll have cases internal medicine injuries. You'll have orthopedic injuries, especially lower extremity injuries, especially knees, ankles, etc., where morbid exogenous obesity in a legion of cases has found to be valid legal a basis for valid legal apportionment of the underlying PD for that body part, condition, or system. So I don't have time to go through all the cases, but I'm just telling you that is one. I want you to get your mind into factors and not just injuries. How about pre-existing asymptomatic conditions? How many of you in this audience think that a pre-existing asymptomatic condition, let's call it pathology, can be a valid basis for non-industrial apportionment? Asymptomatic. Should be a lot of hands going up. A lot of hands, because that's absolutely true. Dr. Carpenter has his hand up because he understands it very well. So let me give you an example of this. This is the most radical aspect of what we're talking about today in terms of 4663 and 4664. I always use the case as the Costa case. It's a very famous case because it's cited in the Lid case, which we're going to talk about in a little while. But in Costa, you had the applicant who is 100% permanently total disabled. He had a lumbar spine injury, and he had lumbar spine surgery, and the surgery went south, and he ended up being a paraplegic. He had a bit of a Hikita issue in there, and this case was pre-Hikita, by the way. And anyway, so the issue is he had this a back injury, and unbeknownst to him, for his entire life, he was born with a asymptomatic congenital lumbar spinal stenosis. That's a pre-existing, asymptomatic, and by the way, it's congenital, narrow lumbar spine canal. So he's 100% permanently total disabled. There are two reporting physicians in that case. Dr. Kent, who's I know very well, neurologist out from Moreno Valley, I think, and I don't know the other doctor, but I do know Dr. Kent. Both doctors said that of that 100% permanent disability, 20% was attributable to the applicant's pre-existing asymptomatic congenital lumbar spinal stenosis. And that was upheld on appeal by the Court of Appeal, and we'll get into lots of other cases. So the fact of having underlying pathology that's asymptomatic or symptomatic, which is easier to do, is not a bar to it being a basis for valid legal apportionment. And that's based on the Brody case, the California Supreme Court. We don't have to guess where that comes from. That is absolutely explicitly and expressly stated by the California Supreme Court in Brody. So let me just tell you about Dr. Kent's report. Here's what he said, and I would urge you to incorporate in some way or another the phraseology that he used. What he said basically is that the applicant's permanent disability, lumbar spine permanent disability, would not be as great as it would be in the absence of this underlying asymptomatic pathology. In other words, his lumbar spine PD would not be as great, as large as it would be in the absence of this pre-existing asymptomatic pathology. What else we got going on here? Psych. I know I don't know if there's any psychs attending today, but psych is a veritable treasure trove of potential non-industrial contributing causal factors. So let's say you have a person who has one of these a I'm trying to think, so complex regional pain syndromes, RSD, these kind of injuries where you have a lot of subjective complaints, right? Not objective findings. You do have some objective findings, but a plethora of subjective complaints. So we have a psych case. Now, these are all cases I'm not talking, these are real cases I'm talking about. There was 20% valid apportionment, and listen to what it was based on. So the psych did some psych testing. And what the psych testing of the applicant disclosed was she had an underlying personality disorder, which was absolutely asymptomatic prior to her date of injury. But it contributed to the applicant's PD related to this RSD or CRPS injury that she had and the resultant PD, because the psych testing showed and confirmed that her underlying personality showed that she had a tendency to exaggerate and embellish her subjective pain complaints and symptoms. Now, that was worth 20% non-industrial apportionment, upheld on appeal. We got another case, carpal tunnel syndrome. Applicant had pre-existing the industrial injury, asymptomatic peripheral neuropathy. Asymptomatic peripheral neuropathy. It's the Morales case, a 2009 case. The judge, who's supposed to know apportionment very well, gave the applicant 37% PD for that carpal tunnel permanent disability with no apportionment, none, zero. It went up to the WCAB on appeal, and the board reversed the judge and found 50% valid non-industrial apportionment of the applicant's carpal tunnel syndrome related to that pre-existing asymptomatic peripheral neuropathy as a contributing causal factor. One second. So there's absolutely no limit on the types of non-industrial contributing causal factors that can be a potential basis for non-industrial apportionment. I'm saying no, there's no limit on what they are. They can arise in a variety of situations. So my famous case that I try and use to demonstrate that is from Southern California. It's a safety member case, by the way. It's a fire captain, Captain Kudelka. So he filed a usual safety member CT, all lots of body parts and conditions, and reporting AME and internal medicine. I think was Dr. Green in that case. Now, Dr. Green didn't know he was famous until he sat in one of my audiences at CSIMS one time, and I brought up this case, and later he was very happy about my bringing it up and letting him know that he was the doctor in it. But here's what happened was, from an internal medicine standpoint, in terms of assessing PD, Dr. Green said, yes, the applicant does have, an injury and has some permanent disability related to gastroesophageal reflux disease, GERD. So as I indicated to you, what you're supposed to do, your analytical approach is, Dr. Green's task was to determine what are all of the industrial and non-industrial contributing causal factors of the applicant's GERD. So 10% non-industrial apportionment. Now listen to this very carefully. I love the way Dr. Green phrased this. 10% valid non-industrial apportionment to applicants' dietary indiscretion. Now, what does that mean? Dietary indiscretion was a great literary way to express that the guy, Captain Kudelka, in addition to having his stress at work that causes GERD, also had, a habit, and he liked spicy food, right? And so spicy food, indulging in spicy food, I call it my Tabasco, Tapatia, Cholula, contributing causal factors of the applicant's GERD PD amounted to 10%, upheld on appeal, 10% valid non-industrial apportionment of his overall GERD permanent disability. So that hopefully you now understand more about this issue, and this is a very basic but important principle, concept, and legal standard related to apportionment is these non-industrial contributing causal factors. I also have to tell you that the law that was passed, 4663 and 4664 in 2004, changed apportionment. So now you could never have apportionment based on what I'm going to tell you right now for 36 years before 2004. What happens, I'm sure some of you have these cases. If you have an industrial injury that aggravates, accelerates, and lights up an underlying condition, makes it worse. Applicant had an underlying condition, pathology, whatever it happened to be, symptomatic or asymptomatic, and it made it worse. Let's say it's a back. It's simple. Made the industrial injury made a prior, the back problem he had before worse. So it aggravated, accelerated, and lit up. Those are all words of art in workers' compensation. So you couldn't get apportionment. A defendant could not get apportionment based on that for 36 years before 2004. Now, after 2004, with 4663 and 4663, when an industrial injury aggravates, accelerates, and lights up an underlying disease process, it's a basis for potential apportionment as long as the doctor can write a report that constitutes substantial medical evidence explaining why it is a contributing causal factor. So slide 2, we're already there. It's the second point I'm going to talk about right now here that's up on the screen. I don't think, and I know, forget to think, I absolutely know. I just finished this year helping to teach apportionment for 2 hours at the California Orthopedic Association annual meeting in Monterey. And I was shocked. I don't know why I'm still capable of being shocked what happened. So I'm talking to them about this element, and that in terms of substantial medical evidence, only approximate percentage of industrial and non-industrial contributing causal factors is required. Listen to that very carefully. It's not, and that's based on reasonable medical probability. It's not based on mathematical certainty, scientific certainty, medical certainty, or whatever it happens to be. It's an approximation based on reasonable medical probability. And I know most medical legal evaluators, QMEs, AMEs, do not like to use the word approximate. I'm telling you, actually not asking you, that it is your best friend when you're trying to write a report that constitutes substantial medical evidence. It insulates your report in part from being found to not constitute substantial medical evidence because it reflects to the judge and to the board that you understand that approximate is the legal standard. We're talking about legal standards, concepts, and principles here. So the correct legal standard is approximate, right? So hang on. Listen to this very carefully. This is from the Court of Appeal, not a board decision. The fact that percentages of causation of permanent disability that the physician provided are approximations that are not precise and require some intuition and medical judgment does not mean the doctor's conclusions are speculative. And let me tell you what else. The reason that approximate is not only okay to use, it should be used, is that if you look at Labor Code Section 4663 itself, you look at 4663C of the statute, it uses the word approximate twice in the statute. So that has a statutory basis for why we use the word approximate. So if you're not using the word approximate now, please fold it into your reports in the future. I know that that you don't like it because you think that it's not certain enough and you're going to get questioned by. But let me tell you, it insulates you during your depositions. An applicant attorney will take you in a deposition, and the first red herring question they usually ask a doctor is say, "So, doctor, with respect to the applicant's lumbar spine PD, you've indicated that your estimate, let's put an estimate for now, not approximation, estimate is 30% non-industrial. Is that correct?" "Yes." "So, doctor, why didn't you pick 31%? Why not 28%? Why not 20%? Isn't this really just conjecture and speculation?" Your answer to that question should be very, very easy. The answer is this: counsel, it's my understanding that my opinion on apportionment is based on reasonable medical probability and can be based on an approximation of the non-industrial and industrial contributing causal factors of the applicant's PD. And nothing more is required. that it is an approximation. I acknowledge it's an approximation based on the applicant's diagnostic studies, based on my exam, based on the records, etc. That's my approximation, and I've explained how I arrived at that approximation and the how and why aspect under Escobedo. You can't just list an approximation. You have to, of course, do some how and why. You explain it, but you don't have to do. You don't have to come up with a precise figure. It's just approximate, and that's legally sanctioned. So please embrace the use of the word approximate in your opinions, and I think you won't go wrong in that regard. So listen to this also it's a case in 2006, Yeager-Gatton. It's from the Court of Appeal. Now this came out right after Escobedo, before the ink was dry in Escobedo. And Escobedo, you're all familiar with. It's the how and why formula of what constitutes substantial medical evidence. The physician has to explain how and why this injury or non-industrial contributing causal factor is contributing to the applicant's PD. So what happened in Yeager-Gatton is the case, Yeager-Gatton. The applicant had a lumbar spine injury, and he had just diagnostic studies up the wazoo showing a severe, significant degenerative condition in the lumbar spine that pre-existed the current injury. Notwithstanding all of that, and the doctor's adequate how and why explanation, the WCAB found the doctor's report didn't constitute substantial medical evidence. Now, this is right after the board had issued their en-banc decision, Escobedo. So what happened was it goes up to the Court of Appeal. The Court of Appeal looked at it and annulled. Now, I want to tell you, we're not in divorce court. When the Court of Appeal annuls a WCAB's opinion on apportionment, they mean, this is why we're doing legal principles for so long today. It means that the WCAB's, not the doctor's report, the WCAB's opinion did not constitute substantial, not substantial, but did not reflect the controlling legal principles and standards related to apportionment. The board didn't apply them correctly to their analysis of the doctor's opinion on apportionment. And that's what happened in Yeager-Gatton. So here's a quote from Yeager-Gatton. Where a physician or medical legal evaluator has made a determination based on his or her medical expertise of the approximate percentage of PD caused by a non-industrial contributing causal components, the appeals board may not substitute its judgment for the doctor's determination. That's very, very important in terms of your, again, embracing the approximate language in your section on apportionment. I also know Dr. Carpenter, he understands apportionment very, very well. And sometimes words are artful and you have to be careful with them. He calls it your apportionment argument in your report. I think argument's not exactly the description you should use. You could use apportionment under your heading, because it all should be in one heading. He's going to talk about this more in his part of his. It should be all in apportionment discussion and analysis, apportionment determination, but that's going to be one discrete part of your medical legal report. But I wouldn't I wouldn't label it as your apportionment argument. You want to render an opinion, and you don't want to characterize yourself as making an argument, I don't think. We'll let the lawyers and the judges deal with the arguments, and you guys render an opinion. Okay, so there's a little bit of history here that you have to understand. You can't understand the concepts and principles of apportionment without understanding the history. But before we get to the history, I don't know, what we're talking about here. We should start from scratch. We're talking about apportionment of permanent disability. And I'm not sure all of you, or even most of the defense attorneys, like I talked to the SCIF attorneys a few weeks ago, have a common shared definition of what permanent disability, and that's what apportionment is all about. So here's my definition of permanent disability, not mine. It's extracted from the Brody case, which is a Supreme Court case, and the Ogilvie case, which is a Court of Appeal case. And it's the best, not mine, but it's the best definition of permanent disability that I have seen so far. Listen to it carefully. A permanent disability is the irreversible residual of a work-related injury that causes impairment in earning capacity, impairment in the normal use of a member, or a handicap in the open labor market. Now that's Brody and Ogilvie. So you can see where that definition of permanent disability spills over into not only underlying asymptomatic conditions, but also into vocational issues like open labor market, et cetera. So that's where when I looked at this definition of PD and correlated with the new Nunes decision, I said, aha, this is where the concepts, principles, and standards starts bridging all of these decisions and link them. And I'll cut to the chase here. What is the controlling legal principle that links every single case that we're going to talk about today? Whether it's Hikita, whether it's Nunes, or whatever it happened, Lind, it is this. When there are multiple contributing causes, industrial and non-industrial, of the applicant's permanent disability, apportionment is required as long as it's supported by substantial medical evidence. When there are multiple contributing causes, if the applicant's permanent disability is solely related to the industrial injury, there's no need to have this discussion about apportionment. And that happens in lots of cases. I see tons of cases as a judge and as an attorney where there is no valid basis for non-industrial apportionment. And in that case, the applicant gets a simple unapportioned award, no problem. But the issue comes up, and that is when there are multiple contributing causes of an applicant's permanent disability, apportionment is required. And you have to come up with those approximate percentages. Let me tell you, there's another way of understanding this in terms of history. So from 1968 to 2004, when Labor Code Section 4663 was enacted and 4664, apportionment of permanent disability based on causation was prohibited. Let me say that again, because that's the radical nature of this law. So from 1968 to 2004, it's 36 years. So from now, 2004 up until now, we have 19 years. So before 2004, you could not have multiple contributing causes of an applicant's PD. What do I mean by that? Simple example. And by the way, the Brody case gives several examples, and in the first 10 pages of my outline, you'll see all of those examples. I don't have time to go into them today. But one example, and I think is a good one, to show you the distinction about where there was no apportionment, a basis for apportionment before 2004, and where there is now, is a case where you had a worker who was exposed to a pulmonary injury, and it was the cause of the injury was exposure to, I think, flour dust or some other deleterious type material in the workplace, right? That affected his pulmonary system. So in any event, so you're looking to say, okay, so what you ask yourself in every single case, what are the industrial and non-industrial contributing causes of the applicant's pulmonary disability? We know that the industrial portion, to an approximate percentage, will be his exposure to the flour dust that he worked in for many years, right? What would be a potential non-industrial contributing cause of a pulmonary disability that could not be used before 2004? The applicant was a pack-a-day smoker. Before 2004, it didn't matter if he smoked 2 packs a day. All of the applicant's PD would be industrial before 2004. There would be no apportionment to his non-industrial contributing causal factor of smoking. It could not be used before 2004. However, after 2004, it's based on multiple contributing causes, industrial and non-industrial. It can be considered a person's smoking, as you'll see in a case we're going to discuss in a minute. It can be considered as a contributing causal factor of the applicant's pulmonary disability. And that goes on for every condition, body part, and system. You're asking that same question over and over again. You focus in, like in Lynn, we're going to talk about. The applicant Lynn, the permanent disability in Lynn was left eye vision loss in the left eye. You ask yourself about all the non-industrial and industrial contributing causal factors of the applicant's loss of vision in his left eye. And you'll see when we get to the Lynn case how they analyzed that and how it was correctly applied. So I wanted to give you that distinction. And by the way, this is a very good part of history here. Not 36 years before 1968, what do you think the apportionment law in California was? Exactly the one we have right now since 2004. So you have this cycle. Yeah, believe it or not. So I forget the exact year, but for 36 years, that's funny, it breaks down that way. For 36 years before 1968, you had apportionment based on multiple contributing causes, right? Like we have right now. And then from 68 to 2004, you could not have multiple contributing causal factors. You had to have pre-existing disability, et cetera, but it was very hard for a defendant to get valid legal apportionment. Anyway, all that stuff, there's a history here in terms of, I don't want to get into it much about former labor codes, all for the lawyers, about being repealed, et cetera, et cetera. Don't have to get into all that for today's president. Yeah, it was from 1932 to 1968, which was very significant historically, where apportionment was PD, was basically what we have now. So again, just to tell you before we get into some cases, I want to give you some real cases, recent cases and cases to illustrate what I've been talking about now, so you can see how these things manifest themselves in real reports that are analyzed by the board and by judges. But I want to tell you the board is wrong a lot on apportionment. I know the judges are wrong on apportionment a lot. I read every apportionment case that comes out. I need to tell you that. Now, I don't miss one. I don't put them in my outline because some aren't important. But I read every single one. So I know where judges have been reversed by the board, and I know where the board's been reversed by the Court of Appeal. There is no other area in workers' compensation. Now, this is with the board, this WCAB, where the board has been reversed. In other words, their decisions are annulled more than in workers' compensation, where the board cannot analyze the report and apply the correct legal standards and principles that I'm trying to teach you today. So these mistakes are manifest all the way up the chain, from your writing the report all the way until it gets to the Court of Appeal and to the Supreme Court. So I just wanted to put that in perspective in terms of the board. So let's look at some cases to try and give you examples, concrete examples of how this works out. Let's talk about the Brophy case. It's in the outline. I think I'll give you the page here in a second. Anyway, it's in the outline. The Brophy case. By the way, the outline is very user-friendly. The apportionment case law, it's about 167 pages long. The July edition has a table of contents in the beginning. And at the end, for those of you who are real apportionment aficionados, savants, and mavens, or wannabes, at the end, there's a table of cases alphabetically. So if you know, like I'm saying right now, Brophy, you can go to the end of the case, the end of the outline, and you'll go alphabetically down to Brophy, and it'll tell you which page the case is on. Anyway, this is a writ denied case. It's 100% permanent total disability. It's a 2021 case. 100% permanent total disability. WCJ's decision at trial. Applicant is 100% permanently totally disabled. Applicant was exposed. He was a truck driver. He was exposed to toxic fumes. I believe it was marine paint at work. So he had an injury, which we already discussed one aspect about flour, but now we're into one related to marine paint. So where's the injury? Pulmonary. That's what you're going to say. So you ask yourself, what are all the contributing causal factors of this particular applicant's pulmonary injury? So the judge said 80% non-industrial apportionment. What were those non-industrial contributing causal factors of the applicant's pulmonary disability to the tune of 80%? Listen to two of them. 20-year history of heavy smoking and morbid obesity, applicant weighing 383 pounds as of the date of injury. So here's the analysis. This is the QME reporting, whose report was found to constitute substantial medical evidence on apportionment. Here's what he says. The reporting QME determined the applicant was 100% permanently total disabled, found 80% based on a lifetime of heavy smoking, actually, and morbid obesity attributable to applicant's dietary problems. The QME was deposed, by the way, and stood by his opinion, everything. Here's his opinion, quote, this is the doctor, not me now. I'm just channeling the doctor. On one hand, you have this tremendous smoking history in an individual combined with morbid obesity. On the other hand, you have a single fleeting exposure to what is reported to be marine paint. I think apportioning 20% to his lung disease to that exposure is very generous. With respect to the applicant's non-industrial risk factors, the QME went on further to say, quote, this patient had extensive non-industrial risk factors for his internal medicine-related pulmonary conditions and complications thereof. Chief among those risk factors are lifelong cigarette smoking and obesity. With regard to the lung disease, however, I do believe that the lion's share of causation is caused by non-industrial factors related to smoking diet. Now, I only did a snippet there of the how and why. I didn't give the approximate percentage discussion. I just wanted to extract that. Okay, now what's important about this decision is that in upholding, obviously the applicant's attorney appealed that 80% non-industrial apportionment and took it up to the board. And the board affirmed the judge's 80% non-industrial opinion. And here's what they said. They applied the Lynn case, which we're going to talk about again in a few minutes. The Lynn case, they quoted, listen, and this is what I've been trying to teach you for the first almost hour of this presentation today. This is a quote from the decision. Where some portion of an injured employee's PD results from a pre-existing asymptomatic condition that is caused by a non-industrial disease or pathology, by congenital or genetic factors, or by other non-industrial risk factors, a physician may permissibly apportion the disability. The Court of Appeal in Lynn expressly rejected the appeals board erroneous conclusion that a mere non-industrial risk factors that predispose the employee to having left eye blindness did not constitute a valid basis for apportionment. And the QME in this case adequately, quote, explained with reasonable medical probability how and why some portion of the applicant's PD was caused by the non-industrial factors. Now, what was interesting about this case, these are panel decisions. A WCA panel consists of 3 commissioners. So there was one dissenting commissioner, and this was kind of embarrassing for me and to look at this, because this is 2021, many years after the law passed. This particular dissenting commissioner would have found the doctor's apportionment invalid. But listen to the reasons. The reasons that the commissioner gave for not finding, the dissenting commissioner, for not finding the doctor's report constituted substantial medical evidence, which didn't matter because she was the dissent, was this. She said the basis for her opinion that the QME's apportionment did not constitute substantial medical evidence is that applicant worked without difficulty since 1996 and worked in this position for the defendant for 3 years, often working overtime and engaging in heavy lifting. She also pointed out that the applicant had never been treated for any lung problems prior to toxic exposure at work. Oh my God. All of that is pre-SB 899 law. All of that. Right now, you can have valid legal apportionment even if an applicant never received medical treatment for the underlying condition, never lost any time from work for the underlying condition, etc. So what she was doing was an analysis of the law before 2004, and it was quite embarrassing, actually, to look at that analysis. But in any event, that's that case. So next case I want to do very quickly is the Colley case. It's a brand new case, 2023 case. It's a 100% permanent total disability case. The reason I picked this particular case is because it has, remember I said I'm an equal opportunist. Doesn't matter if people are QMEs, a judge, commissioner, whatever, AMEs, QMEs, treating physicians. I'm an equal opportunist when it comes to pointing out if they don't seem to understand. This is a case that had 3 AMEs. And by the way, these 3 AMEs, I know, I'm not going to give you their names. These 3 AMEs are very well known in the industry, very well known. And all of them gave an opinion that did not constitute substantial medical evidence for different reasons. What I did not know when I gave this presentation to the California Orthopedic Association was the orthopedist in this particular opinion was in the audience. I didn't use his name. He didn't know what I was talking about when I gave the orthopedic part of this about the AME being wrong. And I found out later that night at dinner. I went to dinner, just sat at the bar, had dinner at the bar because the tables were all crowded. Up comes sitting next to me his partner. And he didn't know that I knew that, and he didn't know that it was his partner. So he says, oh, we talked about what you said about that report from that AME not constituting substantial medical evidence and the reasons. But I asked my partner, he said, whether he was going to change any of the way he wrote his report based on what you said. And he said he wasn't. So I said, okay, I didn't say anything. I absolutely didn't say anything. But listen to what this is a QME, I'm an AME in orthopedics, and listen to what happens. So I might only take the orthopedics part, but we'll look at it real quick. So we're talking about the lumbar spine and the cervical spine. Now, we're not talking about a lot of apportionment here. We're talking about 10% non-industrial for the lumbar spine, 10% for the cervical spine based on an underlying degenerative disease condition or process. Now, here's what the AME's opinion was. I'm going to give you a full because it sounds actually pretty good. But when you apply the principles and standards that I've been teaching today, you'll be able to pierce through this right away and be able to write a better report and know why you shouldn't write a report like this. Listen very carefully about how he explains how he determined apportionment. Now, some of it's a little boilerplate, and I'm sure you guys all use it. That's okay to a certain extent. Here's his opinion. In regard to Labor Code Section 4663, based on my review of the available medical records and the history given to me by the patient, it is medically probable that approximately, God, I like that part a lot, 90% of the patient's disability for lumbar spine was caused as a direct result of the injury of March 15, 2002. Next paragraph. Based on my review of the available medical records and my physical examination of the patient, it is medically probable that approximately 10% of the patient's disability for the lumbar spine was due to other factors, i.e. the patient's non-work-related degenerative disc disease. So I also like another part of what he did here, because it's what I told you Dr. Kent did in the Costa case. Secondary to the patient's non-work-related degenerative condition, the level of disability was greater than it would have been just due to the on-the-job injury alone. I like all of that. But so why did the board say that this report did not constitute substantial medical evidence? Well, look at this. He says, now this is the how and why section of his discussion about apportionment. He says the non-work-related degenerative disc disease. So you're talking about 10%. So he doesn't refer at all to any diagnostic testing. In other words, he leaves out the severity. The severity part, when you're talking about the how and why, and you're talking about a degenerative disease process that is manifested on diagnostic studies, you have to discuss the significance of the diagnostic studies in your apportionment section of the report. You have to say, based on the CT of such and such a date, based on the MRI, it demonstrates X amount and whatever, which could not have been caused by this particular CT injury and pre-existed the current injury, something along those lines. So what he did, again, no discussion of the severity based on the diagnostics for the how and why aspect. And that's it. So that was why it was tossed out. So psych AME. So the internal I'm not worried about because the internal didn't have any apportionment. So the psych AME did one thing that you never want to do. It's a long paragraph here, but basically what the AME did in psych was to adopt and incorporate the orthopedist apportionment determination. There is no argument about what I'm trying to tell you right now about case law. If you're in one medical specialty, you cannot adopt the apportionment determination by a medical specialist in another specialty as your own. Each medical specialty has its own contributing causal factors related to that disability or that permanent disability in that special field. Internal, psychiatric, neurological. Those are all different contributing causal factors potentially of an applicant's PD related to those body parts, conditions, or systems. You can't adopt and incorporate another medical legal evaluator's apportionment determination. You have to do it independently in your field. I mean, the easiest field is psych, man. The contributing causal factors of the applicant's orthopedic PD are going to be, to the most part, the diagnostics, right? The diagnostic, the underlying degenerative condition. That is not the same as the psych. I think in this particular case, there probably wasn't any non-industrial contributing causal factors of the applicant's psych, just like the internal. It should be all industrial for the psych PD, and just as the internal was, he had 35% WPI with no apportionment. So in any event, we got this case where the applicant gets an unapportioned award, right? Now, the most recent case I'm going to talk about very quickly is the Becerra case. Just came out on September 18, 2023. 4 QMEs, ortho, rheumatology, internal, psych, all found their reports did not constitute substantial medical evidence. This is where you learn, and the difference. So you had with apportionment, 64% PD. Once all the QME's reports were kicked out as not substantial medical evidence on apportionment, the applicant gets 92%. That's a big swing because 64% was worth $127,813. So you can imagine what the value is between 64 and 92%. I don't have the dollar value, but it's up a lot exponentially once you get past 70%, because you're almost up to 100% case, 100% permanent total disability in this case. So again, 4 QMEs, ortho, internal, rheumatology, and psych. So let's look at very quickly some of these reports and see what went wrong. Okay, the first one is ortho. Very easy to analyze. One sentence discussion on apportionment in his apportionment section. One sentence. There is no way that a judge, first of all, the judge found this substantial medical evidence. No judge in the system should have ever found a one-sentence apportionment opinion constituting substantial medical evidence. Here's his sentence, one sentence. Based on the history of this patient, I would apportion 80% of her current signs and symptoms to her original injuries and 20% to the continuous trauma. That's it. That's it. Totally, not acceptable in terms of substantial medical evidence, okay? Conclusory statement of apportionment falls well short of the analysis required under Section 4663 in Escobedo. The fact, and this is another way, the fact that the QME undertook a thorough review of applicant's medical history standing alone does not satisfy the requirement that the QME provide an appropriate medical analysis, not argument, analysis of that history and its effect on applicant's present disability. Okay, let's go to rheumatology. The rheumatologist reviews the applicant's medical history, including prior surgeries, medical procedures, prior work comp award, and concludes, apportionment, it is medically probable, you should say probable, but probably, that the pain from these conditions and the resulting surgeries caused the development of fibromyalgia. So you have basically an aggravation theory here. He discusses the resulting factors of permanent disability and concludes that, quote, with respect to fibromyalgia, it likely developed as a response to the original orthopedic injuries and was exacerbated by repetitive use at work and subsequent non-work related medical conditions and non-work related surgeries as listed above. So he concludes, because the applicant was awarded substantial permanent disability prior to working at Tenet and had clear documentation of chronic pain that was not improved by multiple surgeries, it is reasonable to apportion a portion of her impairment from fibro to those work-related injuries that occurred in 1993 through 1998. I would apportion 35% of her impairment from fibro to the conditions that occurred up to and including the May 30th, 2000, when she received a permanent disability rating of 49%. Then he goes through the rest of this. Okay, here's what's wrong with that one. The analysis does not identify with particularity the factors or conditions that are causing applicant's disability, whether industrial or non-industrial. Rather, the QME aggregates what she described as applicant's complicated case of multiple work-related injuries and non-work-related medical conditions that necessitated multiple surgeries that occurred over many years into a single factor of apportionment and assessed a percentage of causation to that single factor without substantive discussion of how and why it is resulting in permanent disability. He has not offered an analysis that identifies or parses individual factors and conditions and how and why each factor or condition is causing applicants' present levels of permanent disability. You can go on and on here through the internal. All this is invalid. Internal was a hypertension, 20% industrial, 80% non-industrial. That was invalid. Here's what that doctor said, actually. And very well renowned AME. Of the hypertension impairment, I would say of the 20% would be due to the aggravation of the stresses and strains of her work and the stresses and strains of the orthopedic injuries she has had. The remaining 80% would be due to the non-industrial factors, including he should have said the approximately about the 80, but that was present in non-industrial. Insofar as the arrhythmia is concerned, that occurred both from her pre-existing myxma, heart problem, which is non-industrial, and I would say that 80% would be non-industrial and 20% of the stresses and strains and emotional factors of work and the stresses and strains for orthopedic problems are work-related. He described his conclusion as medically most probable that 80% of applicants' disability would be non-industrial. Here's what the board said about that. However, the QME's analysis is non-specific as to the factors to which he is assigning apportionment, and he further aggregates multiple factors, such as work stresses and orthopedic injuries, without specific and individualized assessment of how and why each factor is presently contributing to applicants' residual permanent disability. The analysis does not discuss how and why applicants' pre-existing non-industrial factors of conditioning are causing approximately 80% of her present permanent disability. Psych is the same thing. I won't belabor that at all. Before we move on to the Lynn case, I want to, again, I asked this question to the SCIF attorneys, and I was surprised by their answers. So if the SCIF attorneys couldn't answer it correctly, some of them, I wanted to make sure that you understood it. So some of you may have heard this concept, but in workers' comp, it's just as applicable as it is in civil litigation and civil negligence cases. So there's a concept that's called taking the plaintiff as you find them. In other words, the eggshell plaintiff. You take them as you find them. When they get injured, that's too bad. Whatever they have, you get to, you subsume it. Well, in workers' compensation, listen to this very carefully, for workers' compensation, for purposes of injury, AOE, COE, I didn't say apportionment now. In workers' compensation for injury, AOE, COE, the defendant, the employer, takes the applicant as you found them. In other words, if they had underlying conditions, pathology, and whatever it happens to be, when you're doing your injury AOE, CO analysis, you take them as you find them. So that's just the way it goes. That's based on two big cases. It's based on the South Coast framing case, and it's based on the McAllister case. That only 1% of the AOE COE causation has to be industrially related to have an industrial injury. What differs in workers' compensation from what it does in negligence in civil litigation is this. It doesn't carry over completely the eggshell plaintiff when it comes to apportioning the permanent disability from the injury, because as I've explained to you, the defendant gets the benefit of being able to apportion the applicant's resultant permanent disability from the injury to industrial and non-industrial contributing causes, which you generally cannot do in certain other litigation forms or contexts. So that's the difference in workers' compensation, and also this distinction between injury, AOE, CO, and permanent disability. I wanted to mention one case very quickly, and I'm going to go on to the Lynn case, and we have plenty of time for questioning here. I want to mention, Dr. Carpenter and I were talking about this when we were preparing for this. I wanted to talk about, if I have it here, Duncan case. Hang on. Some of you may have heard about this Duncan case. It's gotten a lot of press recently. Let me give you the basic facts. So, I'm sorry, it's not Duncan, it's Duran versus County of Imperial. And this basically the facts in this case are very simple. The applicant was working, and a shelf came down and caused a contusion in her head. A very slight contusion, by the way, not significant. What she didn't know is that she had an underlying condition we've talked about, which was a malignant tumor. Had never had any symptoms, lost no time from work, etc. So the question then became, so we know that the contusion to the head, and this exemplifies what I'm saying right now about the eggshell plaintiff. So we know for purposes of AOE COE, you take the plaintiff as you find them, right? For AOE COE. But anyway, it went to trial, not on apportionment, by the way. I'll get into that in a second. It went to trial on whether or not the underlying malignant tumor that was aggravated and exacerbated and lit up by the contusion to the head was injury AOE/COE. How many of you think that, now I'm not talking about apportionment now, how many of you think that the tumor, not the contusion, is AOE/COE? Quick show of hands. Good. It is AOE/COE. And it was based on the opinion of the treating neurologist in the case, who, by the way, was not your run-of-the-mill treating neurologist, John Hopkins neurosurgeon, who happened to be the applicant surgeon. He pointed to the literature showing that this type of tumor can be exacerbated, accelerated, and lit up by even a minor blow to the head. So as a result of that, for injury AOE/COE, the board made a determination that both the contusion, of course, was AOE/COE, but also the underlying condition. So the question I'm raising to you, now that I've tried to teach you all the controlling principles and standards, is this. When it comes to the permanent disability, which was not in this case, it's an AOE/COE case. By the way, the two cases that were cited by the board were South Coast Framing and McAllister for finding the brain tumor was injury AOE/COE. How many of you think that there is a basis for apportionment of the applicant's neurological PD to the underlying pathology that pre-existed the contusion to the head? How many of you think there's a basis for? Yes, you are correct. There's nothing in the case yet because it hasn't gone that far yet. It's going to be no different than the case we're going to talk about here in Lynn, because anytime you're dealing with pathology, underlying symptomatic or asymptomatic pathology, you're going to apply the principles in Lind, and that is yes, because it was, even though it was aggravated and accelerated, it's still this non-industrial, it was a non-industrial contribution. That malignant tumor was not work-related. It's work-related in terms of injury, but the PD is non-industrial. So I asked the SCIF attorneys, what percentage, roughly off the top of your head, would you think that is going to be non-industrial, the tumor? They all came up with about 70%. I think that's about right. I don't know, just based on everything, but you'll see why when we get to Lind. So we have time, and I want to get into Lind because this applies across the board to basically all pathologies. It doesn't matter what they are, and that's why this case is so significant. We can go to that slide there. So I'll tell you the slide here for a second. It's Takeda, Benson, farther up, I think. Okay, well, hang on. I got the slide number. Lynn is slide number 4. There you go. Causation of injury and causation of permanent disability, contentious and continuing issue. So I want to give you a little bit of background. And first of all, you should all be cognizant of this. The reason I'm talking about it, because this applies to a lot of big, high-value cases. We're talking about strokes, hypertension, diabetes, long COVID. All these are usually, when you're talking about underlying pathology in these cases, you're talking about some major PD generally. So let me lay there, before we get to the Lind case, you have to have a little bit of history again, and that's why history is important when you understand the principles and concepts of apportionment. So before Lind was decided in 2018, and by the way, the attorney was William Davis. Dr. Carpenter, was that the attorney you had before, Defense Attorney of the Year? Dr. Carpenter? Was William Davis? I think that must have been, you said he was a Defense Attorney of the Year, but he was Defense Attorney of the Year in, I think, 2019, right after this case was decided. And he said, and I know Bill very well, he said he used, as part of his argument, the Costa case, which I gave you before about the underlying congenital asymptomatic lumbar spinal stenosis case in winning this Lind case. But before 2018, there was this long-standing misinterpretation of the Escobedo decision by the WCAB. And it wasn't just once or twice, it was a persistent misinterpretation. And here's how they misinterpreted Escobedo for all these years when it came to apportionment related to underlying pathology and asymptomatic conditions. For up until 2018, the board said there was a bright line between causation of injury and causation of permanent disability. That if you had an underlying factor, say like that brain tumor, or like in Lind, we had an underlying asymptomatic hypertensive eye condition. If you had this underlying pathology, it was a, quote, mere risk factor of injury, but could not be used as a basis for apportionment in the same case. So there was a demarcation, either or. So in almost all of these cases dealing with pathology for many years up until 2018, the board would not recognize asymptomatic condition, even though Brody in the Supreme Court said it was a basis. So board ignored Brody, which they shouldn't have. It's a Supreme Court case. And we're saying in many, many cases, diabetes, all these hypertension cases, stroke cases, that all the underlying conditions that formed the basis for the severity of the permanent disability in those cases, if it was an underlying pathology, that the defendant could not get any apportionment. So before we get to the holding, they always call it a mere risk factor. So now you'll find out how that's changed with the Lind case, which has turned everything on its head since 2018. So let's give you the facts of Lind if you're not familiar with it very quickly. In Lind, you had a police officer with the city of Petaluma. He was engaged in canine training. He had a helmet on and full clothing and garb and everything, and he had a couple of blows to his head, minor blows to the head with a dog or whatever, boom, boom. And so all of a sudden, he doesn't have any, he doesn't fall down, doesn't have any injuries that day, doesn't report anything the next day, goes home. 3 days later, he wakes up and he's lost almost all of the sight and vision in his left eye. That's the basic facts in Lind. So he obviously takes himself to the emergency room at, I think, UC San Francisco or somewhere up there, and Kaiser up there. And the non-comp doctors made a determination right away that this is non-industrial when they looked at the underlying condition of the eye. And what the applicant had as an underlying asymptomatic condition was basically, and there's a medical term, a description of it goes on for 3 sentences, was basically a hypertensive condition of the left eye. The narrowing of the blood vessels going into the left eye was what his underlying condition is. And it was asymptomatic, pre-existing, never lost any time from work, never received treatment for it, may have had a headache or two before, unclear. But we're talking about an aggravation here, that the multiple blows, minor blows to the head, aggravated, accelerated, and lit up this underlying disease process of the hypertensive condition in the left eye. So it goes to a QME in neuro-ophthalmology, which I like. I always tell my audiences, if I'm ever born again and I'm in another life, I don't want to be a lawyer. I want to be a neuro-ophthalmologist. There's something sexy about that dual kind of medical specialty. I think it's fascinating. So I've never met one in person, but I know they exist, the neuro-ophthalmologist. So here's the QME neuro-ophthalmologist renders an opinion. He goes into it. He looks at this underlying asymptomatic condition. He says 90% of so what we're doing here is determining what are the multiple contributing causal factors, if any, of the applicant's loss of vision. That's the permanent disability, loss of vision. So the doctor opines initially 10% industrial, 90% non-industrial. He's deposed, or he writes a supplemental report, changes his opinion to 85% non-industrial. By the way, even without apportionment, the impairment rating on this, or even after adjustment for age and occupation, was 46%, loss of vision in the left eye. So you're talking about apportionment potentially of 85% of that for a peace officer that reduces that value down to almost nothing, basically. So anyway, what happens is the city of Petaluma doesn't want to settle the case. They're denying, not the blows to the head, but they're denying that the blindness is work related. So they take it to trial. They lose at trial. It's at the Santa Rosa WCAB district office. The judge, of course, does the right thing at that time. He applies this rule that the board had interpreting the misinterpretation rule of Escobedo, saying the underlying hypertensive eye condition was a mere risk factor of injury, but is not a contributing cause of the applicant's resultant PD of loss of vision in the left eye. That's what the judge said. It goes up to the board, on appeal to the board, and of course the board's going to say what they said before. Of course, you can't get any apportionment related to this underlying asymptomatic hypertensive condition in the applicant's left eye. That's the law. That's our reading of Escobedo. So it goes up to the Court of Appeal. And I have to give it to Bill Davis, taking up a 46% case all the way to the Court of Appeal. That's very costly, but he did it because he believed that there was a valid basis and good reason for apportionment in this case. Takes it up to the Court of Appeal, and the Court of Appeal annuls the WCAB decision and basically says, look, you reading, they said to the board, you read and misinterpreted your decision in Escobedo. What it says, now this is very important, what it says, Escobedo really says, is that you can have an underlying factor like this that is a contributing cause of the applicant's injury, which it was, and also be a contributing cause of the applicant's PD, but in different percentages. That's what the board was missing in their misinterpretation of Escobedo before Lynn came out in 2018. So the lesson from Lynn that you all should take, by the way, is this, that when there are multiple contributing causal factors of an applicant's permanent disability, industrial and non-industrial, whether it's underlying pathology or a prior injury, apportionment is required when it's supported by substantial medical evidence. So I don't care if the underlying pathology is diabetes, hypertension, whatever it happens to be. Let me give you an example why this is a continuing and contentious issue. The board, for some reason, and when I trained the SCIF attorneys a few weeks ago, there were two commissioners sitting in the audience because they were on the panel after mine. They were sitting there, Commissioner Razzo and Snellings, and they were taking notes. And I said, look, the board, look, pathology is pathology. Diabetes may be a little bit more complicated than this Lynn issue, what the underlying pathology was, but it's still pathology. The reason that diabetes apportionment is difficult is because diabetes can affect so many different conditions, symptoms, and body parts than other pathologies when it goes sideways. So the big example of this is my outline is the Weiss case where the board got it completely wrong. And I said this to the commissioners. I said, look, I'm not shy about this. They took it good naturedly. I mean, they know I'm trying to say, what I think is the correct interpretation of law. In Weiss, you had somebody who was a plumber for the correctional department who had underlying diabetes and stubbed his toe. And that was a work-related injury, no doubt about it. And then, of course, in these diabetes cases, if you know anything about internal medicine, et cetera, they start going south right away. So he developed an infection, went back to work, developed more problems. Next thing you know, one thing led to another. That little scrape to the toe becomes below the knee amputations, long story short. So the issue became, is there a valid basis for apportionment into this situation? So you ask yourself the same question. So the PD, however you rate it, look at it, it's going to be what was the applicant's loss of limbs or loss of those two limbs and the need for the surgery, the amputations, was that all industrial or non-industrial? And the board gets all confused because it's diabetes. You just apply the same. Sorry, that's my phone for the time for questioning almost. We'll get that in about 4 minutes. So I'm going to finish. So anyway, I'm still saying that this is a contentious issue. The board got it wrong in Weiss. And I think that Commissioner Razzo especially was very receptive to my saying it. You do the same analysis across the board, no matter what the pathology is, no matter how widespread the pathology is, you just make it a determination. So you'd ask yourself the basic question, as you would in Hikita, was the applicant's surgery, in this case, the below the knee amputations, related in part to the industrial injury? Of course. And was it related in part to an approximate percentage to the underlying non-industrial condition, which was diabetes? Of course it was. You just have to come up with the approximate percentages. He wouldn't have had the amputations, but for his underlying diabetes, he would just had a scrape to the toe that got infected as a work injury, right? So just look for this analysis in real cases. I said again to you, long COVID. If any of you have long COVID cases, this is going to be a big issue because long COVID affects so many different body parts and systems, just like diabetes does. But underneath all of those, various systems that long COVID can affect, you may have pre-existing comorbidities, pre-existing pathology that you may have a basis for apportionment for. So that's Lynn in a nutshell. One more very quick one before we get to questions. I wanted to, because it's not a huge issue for most med legal evaluators, but it's significant and that's because all of you as reporting med legal evaluators usually get, and especially in high exposure cases, really high exposure cases, you're going to get vocational reports. How many of you gotten vocational reports operating as a med legal evaluator, right? From vocational experts, defense, applicant, right? Occasionally. All right. Well, I don't know what the specialties are, but they're pretty common because what the vocational evidence is being used for is to rebut the scheduled rating, right? You have a scheduled rating, which you guys never see. You do the impairment, and then you don't see what happens to that impairment rating when it's adjusted for age and occupation. You never see it, I don't think. You just see the impairment, which doesn't have those two factors in. But when it goes to a rater, the rater takes your impairment assessment with and without apportionment and adds age and occupation. That formula can change that impairment up quite a bit, especially with Almars, Guzman, and Kite, et cetera. So in any event, this whole issue about Nunes is vocational apportionment. Vocational apportionment is absolutely non-descriptive. It should be called vocational non-apportionment. I wrote the definitive article in it in 2021, 17 pages long. There's a link to it in my apportionment case outline. You can find it online too. If you Google my name, you'll see it comes up, Lexis article. So 2 years ago, long before this Nunes case came out, I had already made this criticism, embodied a lot of stuff that the board incorporated into their Nunes decision. Basically, what the applicant's bar was trying to do was to use this concept of vocational apportionment to negate and to undermine medical apportionment under Labor Code Section 4663 and 4663. So what the board has done in these two en-banc decisions, they've issued two of them on the same topic, Nunes 1 and 2, one on 6/22/23 and the other on 8/29/23, is to say vocational apportionment is not a valid basis to offset substantial medical evidence of medical apportionment. and it cannot be used. It cannot be used to, again, as a basis to rebut a scheduled rating at all. So you can have traditional vocational evidence, but you can't use this, quote, vocational evidence, which was being used a lot. I don't have time to get into the cases just before this case came out that would have graphically demonstrated to you how it was being used to circumvent and negate 4663 apportionment. So basically, hang on for a second. The three holdings are this from Nunes, because reporting physicians still are going to get vocational evidence to try and use this. The three holdings of Nunes is Labor Code Section 4663 requires a reporting physician to make an apportionment determination and prescribes the standard for apportionment. That's what I taught you for the first hour, the standards for apportionment. The Labor Code makes no statutory provision for vocational apportionment. 2, vocational evidence may be used to address issues relevant to the determination of permanent disability. They're still saying vocational evidence is good, but you can't use this device to rebut medical evidence of apportionment. And vocational evidence must address medical apportionment and may not substitute impermissible vocational apportionment in place of otherwise valid medical apportionment. So that's the three holdings. If I'm doing it for lawyers, we get into a lot more of that history of it. You don't really need it for today's presentation. So I'm checking the clock here, 10:41. So Dr. Carpenter, if it's okay with you, we'll start taking some questions. If we run out of questions, I can go back and pick up on Hakita or whatever we have time we left. But I want to make sure that everybody who's attending today, we can try and fully address the questions that you have.
Okay, great. Okay, great. If everybody would unmute, we'll go to the chats and the questions.
Did you unmute people?
Okay, so does anybody have a question? Does anybody have a question that they want to ask Mr. Corio? Mr. Corio?
Yes. State your name first, because there's so many people up on the screen. Who's the question from? Who's the question from?
You're muted, Dr. Kasha.
Yeah, it's reverberating.
What's the fix on that?
I think the fix is to mute everybody except for the person talking.
That's it.
Or the person's talking. So you're going to have to unmute people individually later.
Okay, let's see how we can do this.
So mute everybody now, and if you can, and then can you unmute?
Okay, Mr. Corio, go ahead and unmute yourself. Mr. Corio, unmute yourself. Are you hearing me?
Okay, yeah, I can hear you now.
Okay, so who has the first question? Anyone? If
Just
not, we'll
unmute
read
yourself.
from the chat.
Make sure you unmute yourself.
Hey, I'll throw it in there.
Okay, there you go.
I've really appreciated your information. This is great, and Perry, this is a great opportunity to get this in more depth. That's my only comment, really. But otherwise, I need to be able to copy notes, and if there's any way to have the slides, because there's a lot of information.
You can have them.
Fantastic. Yeah, I appreciate all your efforts.
And the outline, I don't know how Perry's going to distribute the outline or not, where you can always find it on the Perlman, Brown, and Wax website under educational materials.
Perfect. Thank you.
Yeah.
You should all have the outline and the download materials. I put that in the chat. There's a link there. And I'll just show you what that looks like.
Okay, so I have a question.
Okay, who's this?
Adrian Coral.
All right, go ahead.
What you talk about these percentages, 80%, approximate. I mean, how do you get these approximate percentages? Based on what? I mean, you say CT scan of so X-ray scan, degenerative changes. Okay, well, how do you know how do you get this number? I mean, it's kind of approximate. Well,
that's exactly why it's an approximation. And how you get the number, especially when there's diagnostics, CT scans, MRIs, it will demonstrate the severity of an underlying degenerative condition. Not all underlying degenerative conditions are the same. So you would say that based on the severity, based on the diagnostics, which you factor into your apportionment discussion, the how and why in there, and also I think you put in the surgical history to some degree. If an applicant's had 4 prior knee surgeries or 2 prior knee surgeries, you put that history in there, as that would put in perspective the diagnostics even more on bone, like the Justice case, which is the one that limited Hikita. The applicant had bone on bone, arthritis and her osteoarthritis in her knees before the current injury. So there should be, when you look at the severity of that degenerative condition before the current injury, that would lead you to say there should be significant non-industrial apportionment. Again, approximately, it's just an approximation. So you could, as long as you're basing it on something, which is, again, the diagnostics, the clinical history, your intuition and clinical judgment. The Court of Appeal case I read to you says that approximation can be based on, it's not scientific certainty, medical certainty, can be based on a certain degree of the doctor's intuition and medical judgment. So that's what it is. It's acceptable.
Okay, next question from the chat. We have a doctor that says, asks, when you have a cumulative trauma injury that's caused over 27 years, work, in order to qualify as an industrial injury, work has to be shown to contribute only 1% to the disability, and perhaps even lower under the South Coast framing case, huh? How would you apportion that? He says injury, I think he means disability.
Well, again, you have to take it, don't forget, we're talking about apportionment of permanent disability for each discrete body part, condition, or system. So a CT can involve multiple body parts, conditions, or systems. You take a professional athlete, by the way, and you'll find how complicated those cases are, because you've got, a 15-year, 10-year career of extremely arduous CT causing work. And so you have to make, an approximation of how much of the, there'll be some specific injuries in there also, probably if you have a professional athlete. But on a CT, again, it's the diagnostics, et cetera, that go into the formulation of the approximation figures. So you can, if somebody has, let's assume this way, somebody has a job that's not very arduous, not a factory, not heavy lifting, not this, not that, and yet has an underlying non-industrial degenerative condition, you're going to say the percentages are going to shift to the non-industrial component as opposed to the industrial component. Where if somebody has arduous employment on the other on side, that percentages will probably shift in favor of industrial percentages higher than non-industrial contributing causal factors. And let me tell you this, because it ties into factors that I tried to talk to you about. A lot of sports attorneys, applicant attorneys, try and file a CT, and they won't file even significant specific injuries, say to a knee. And the reason they do that is they think they can avoid Benson. Well, they can try and avoid Benson to a certain respect, but here's what happens. If an applicant, if a professional athlete has, let's just say, a left knee injury, and he had it in the game, and he was carried off the field, had immediate surgery that day or the next day, and then was off for 2 months, came back and played, but then really that knee injury was really the end of his career. He was never the same as he was before the knee injury. He has, of course, had a cumulative trauma injury, but he's also had a significant specific injury. So when you're assessing the left knee disability, the fact that an applicant's attorney hasn't pled the specific doesn't mean it's not a contributing causal factor of the applicant's left knee permanent disability. That's the difference between factors and injuries. So you can't get around 4663 by not pleading something. So if you find something in an applicant's history where they've only pled a CT, or they pled a CT in one or two specifics, and they've left out other significant specific injuries to that body part, condition, or system, you can factor that into the potential non-industrial aspect of the permanent disability. You can factor that in. So I know look, the CTs are difficult, but I just think when you do it body part by body part, you may have some body parts and conditions where there's no apportionment. You may have others that there's significant apportionment. You do it by body part, condition, and system. You break it down to each one that is, part of the litigation that's either accepted or found as industrial. And then you say, okay, no, with respect to the applicant's right shoulder, there was no non-industrial contributing causes of the applicant's left shoulder, so all the PD's industrial. Easy to say, easy to do. That's easy.
So very interesting. So you cite the circumstance where the attorney may have pled only the cumulative trauma portion of the injury and omitted any reference to specific injuries as a strategy to
significant specific injury.
To avoid apportionment under Benson. We frequently see cases that involve both specific and cumulative trauma injury claims. What is the strategy behind that?
Well, my sense is I think they think that it's going to be difficult for the doctor to apportion the permanent disability among and between the separate and successive injuries. If we run out of questions, as a matter of fact, I'll go to Benson. But here's what I want to teach you very simply about Benson. Benson is not exactly 4663 apportionment. You would need, if you're a doctor, a reporting med legal evaluator, and you have a case that involves multiple and successive injuries, a CT and two specifics, no matter what the mix is, but multiple and successive injuries. Even if all of the applicant's PD is non-industrial to every body part and condition for all of those injuries is non-industrial, the PD among the industrial PD, all of it, has to be apportioned among and between the separate and successive injuries. That is a one-step. That's why it's not exactly 4660 apportionment, and why it can have an impact on an applicant's case. Even if all the applicant's PD, let's take a simple case. The CT is to a back, two specifics to a back. There's no non-industrial apportionment related to the applicant's lumbar spine at all. But because the applicant has multiple and successive injuries, a CT and two specifics, the doctor, it has to attempt, actually it's required, the doctor is required, and I'll tell you when he doesn't, he or she, is required to apportion the PD, even though it's all industrial, among those separate successive three injuries. The only basis for a doctor not doing that is, quote, and this is right out of the decision in Benson, in limited circumstances, which in common English means not very often, infrequently. Limited circumstances where the doctor cannot segregate the residuals among the separate and successive injuries. Now, there are limited circumstances where a doctor would have a difficult time apportioning PD to one body part or all of whatever body parts are at issue among separate and successive injuries. You might have CT, and then you have two back injuries that are a month apart, right? A month apart. You would be hard pressed as a doctor sometimes to segregate the residuals of, unless one was really super significant and the other one was minor, two low back injuries that were weeks apart, right? Which one is more cause of the applicant's lumbar spine PD than the other? So in those cases, the doctor should be able to explain why they can't parcel out and apportion the applicant's PD among the separate and successive injuries. The other aspect of Benson is when you do have non-industrial contributing causal factors of the applicant's PD. So it's a two-step process. That's a two-step process in the example I gave you where you have a CT and two specifics to the applicant's lumbar spine. Let's assume there's 20% non-industrial apportionment based on a degenerative underlying condition in the lumbar spine. So you're trying to say first of all, you do the non-industrial apportionment, and then once you apply that, you're left with the residual, which is all industrial. That is what's being apportioned under Benson. You're not apportioning the non-industrial among the Benson injuries. You're only apportioning the industrial factors among Benson. That's what makes it a little bit complicated for people.
So first handle the 4663 and then handle the dates.
That's what it is. And then whatever the residual is, you'll say, okay, I did my apportionment analysis. My apportionment analysis as a doctor is it's 80% is of the CT is non-industrial, industrial, 20% non-industrial, 10% non-industrial for the first specific, 10% non-industrial for the second specific. So therefore, with respect to the remaining industrial component of these three injuries, I would apportion as follows among these three injuries.
Got it. Okay, great. If there are any last questions, we'll take a 5-minute break. But are there any last questions for Mr. Carrillo?
Question. Can you hear me okay?
Yeah.
Yes.
Yep. So have you ever seen diagnosis-based estimates used as a basis for apportionment? I mean, I know you can't do direct subtraction, but for example, if the person has severe arthrosis in their back or pre-existing, disc herniation or something like that.
I just got a message on my computer says my internet connection is unstable, but I didn't hear all of that.
I'll do it again for you. Can you hear me now?
Yeah.
Okay. So have you ever seen DBE used as a basis for apportionment? I know you can't do direct subtraction, but knowing that, for example, if the person has severe lumbar degenerative changes or a disc herniation that pre-existed, as a way to give an estimate for apportionment. Have you ever seen that used?
The only way I've seen that, the ROM and DRE you were mentioning, right? DRE?
Yeah, the diagnosis-based estimates.
Yeah. So the only way I see those coming up is usually when you're trying to apportion about a prior award. So if you're going to make your DRE estimate is whatever it is, that's the basis of it, but you're still apportioning. Let's say you're apportioning to a spine, right? The DRE, right?
Right. We're saying if they have pre-existing, like you said, arthrosis or degenerative changes, the guides gives the diagnosis. There's the DRE, but then there's the DBE, or the diagnosis-based estimate portion of the book that says, if you have, a disc herniation, it's X. Or if you have severe arthrosis, it's X. Or if you have spondylosis, it's X.
Right. So that all helps you determine the impairment. So you're using all those things to determine impairment, not apportionment. However you decide what the level of the impairment is, your next question is, what are all the contributing causal factors? You can call it impairment, which you should do,
yeah,
or permanent disability, and then you do your industrial and non-industrial factors. Your question now has provoked something I should have said before. There are some doctors who, when they're deposed or in their reports, use examples from the AMA guides as part of their apportionment opinion, because if you go through the AMA guides, there are lots of apportionment examples in the guides based on different body parts and conditions. However, this is right out of a real case. So doctor deposed. Doctor, how did you come up with your approximation and of your formula with respect to industrial and non-industrial causal factors? Oh, I just used the example in the AMA guides for this body part, whatever it was. The judge and the board reversed them. You cannot use an apportionment example from the AMA guides unless it's consistent with Labor Code Section 4663 and 4664. If you look at Chapter 1.6b of the guides, the AMA guides acknowledge that some states, like California, have their own apportionment laws, and therefore their examples in the AMA guides would not control as to apportionment. Now, you can use an AMA guides apportionment example if it's consistent with 4663 and 4664, but you'd have to determine that based on like going to a webinar like this, or determine whether it's consistent with the principles that I've tried to teach you today. Anyway, perfect. I think the DRE and the ROM thing is just determining what the impairment is. You still apply the same analysis apportionment of that, what that impairment is.
Okay, thanks.
Okay, let's pick up and let's keep going.
Can I just ask one quick question, please? Yes or no?
Sure.
Can you hear me?
Yeah.
Yeah, I was just asking, I know we don't want to get into peace officer presumptions, but I was just asked, does apportionment apply to Department of Corrections employees?
It can or cannot. It depends on whether they're sworn. Department of Corrections officers.
Yeah, if they're a peace officer and they carry a,
then you'd still would have for the non-attribution, you got Labor Code Section 4663, you got skin cancer, all that sort of stuff, 4663 A, B, and C, whatever. You got to look at, unless it's covered under 3212 to 3213. So there's certain conditions where you can't get any non-industrial apportionment for. You cannot, based on the anti-attribution, it's called statute. It's part of the statute.
they're not, does that apply to corrections or other?
If they're safety members, if they're peace officers and they're safety members, I think those presumptions apply. I don't specialize in safety member cases. But
I'm pretty sure the Department of Corrections is not specifically mentioned in any of those codes, 3212 up through 3213.
Yeah, so I was wondering if they got covered under anything else, under case law or anything.
Yeah, okay.
They're not specifically mentioned in the list of, I don't think that, in the departments that would be involved, the peace officers that would be involved, like state, city,
Highway Patrol,
department,
Sheriff's Department.
Pardon?
Sheriff's Department.
Yeah, University of California, and that's about it.
Right. So again, I'm not an expert in safety cases. I did them when I was initially a new attorney in workers' comp many years ago, but I haven't done them since.
Oh, okay. Sorry. Okay.
Okay, so let's continue. So I'm going to take over the microphone now. Thank you very much. And thank you, Mr. Carrillo, for that fascinating stuff. I'm going to build on a lot of what you talked about. I'm going to clarify, for the purposes of us that are QMEs, I'm going to clarify some of the ideas that Mr. Carrillo put out in front of us. And then we're going to save a good 30 minutes out of this hour for some actual cases. I want to show you how to write this up in the body of your report. So let me lay a little foundation for that. And as Mr. Carrillo said, apportionment is the single most impactful financial driver of the case. Now, I used to not understand this. I used to think that, by the time we get to apportionment, especially for low permanent impairment cases like we deal with, I used to think that by the time the horse had already left the barn, the claims payer had already paid for 2 years of temporary disability benefits. They've already paid for medical treatment benefits. I thought that, to save a few percentage points on apportionment after the horse had already left the barn was a small financial driver of the case. But according to Mr. Carrillo and others I've heard from, especially as we get into the higher disability cases, it's the single most impactful issue that drives the case. And many times we don't know this as qualified medical evaluators, but there's other medical evaluators also involved in the case, and we may not know the full scope of the case if we're simply dealing with the orthopedic element of the case. So we don't really know what's going on behind the scenes, but still it's incumbent upon us to give a full effort and a full discussion of our apportionment approximate percentages, even if we're dealing with only what seems to be a small impairment value. So as Mr. Carrillo said, the new approach to apportionment requires us as medical evaluators to look at the disability, and we can use the terms impairments and disability basically interchangeably when we're talking about apportionment. So we look at the current impairment, and we parcel out the causative sources, the non-industrial sources, the prior industrial sources, and then, of course, the current industrial injury, and decide the amount caused by the current industrial source. Now, the great question circulating among QMEs, and we already heard it here today, is how do I decide? How do I do it? How do I determine the amounts caused by the industrial source and the amounts caused by the non-industrial source? And there's a science to this, and we're going to get exactly into that here as we go. So important for us to understand that apportionment is applied to the final adjusted rating of permanent disability. It's not applied to the standard AMA guides impairment rating. So as you know, in coming up with permanent disability ratings, this is done down in Oakland at the Disability Evaluation Unit, and the raters down there, they use our impairment rating percentages, and they adjust our impairment rating percentages according to formulas. They adjust it for age, they adjust it for occupation, they go through charts and tables, and they use our impairment percentage to come up with a permanent disability rating. And it's this permanent disability rating that then gets adjusted by our apportionment approximate percentages. It's applied to each body part rating string as appropriate, and it's not applied to an overall rating of disability after the disability of all body parts is combined. So this is a key secret for us when it comes to putting together our apportionment discussion. We're going to do a discussion for each body part. And I'm going to share with you a novel idea about actually even considering the multiple impairments that may be involved for each body part and providing a discussion of the apportionment of the impairment, each of those impairments for each of the body parts. So you can see that this can get to be quite a bit detailed, and I'll show you exactly how to do it. Okay, so a little bit of history about this. Mr. Carrillo made reference to this. I think it's important for us to understand the philosophy behind the new apportionment laws, which are 4663 and 4664. So these laws came to be in 2004 with the passage of this bill, Senate 899. As I look around the audience here, I know many of you, judging by the amount of gray hairs in the audience, I know many of you were around during this period of time. I was around, and I remember when it happened. And the purpose of Arnold Schwarzenegger signing this bill into law in 2004 was several-fold. It was to promote efficiency. I won't elaborate on that. It was to enhance benefits. It was to help combat fraud and abuse. And for our purposes, this is what's important for us to understand. Part of the purpose of Senate Bill 899 was to help reduce what was referred to at the time in 2004 was referred to as skyrocketing costs. Senate Bill 899 was passed in an effort to address what was referred to as skyrocketing costs. So the legislation aimed to control and reduce overall costs associated with the workers' compensation system. It introduced several measures to achieve this, including implementing stricter guidelines for evaluating permanent disabilities. And that's where these new apportionment laws came in. This Senate Bill 899 ushered out our prior apportionment law, which was Labor Code 4750, which I never really understood at the time anyway. And I was doing QMEs back here in this time, right around 2004, 2005, and even before 2004. I never really understood it. And then Senate Bill 899 revised existing Labor Code Section 4663 and introduced in new Labor Code Section 4664. So let's go over a couple of the key definitions and descriptions from these labor codes. So first, 4663, and I know you've all seen this, but I want to point out a couple of the nuances associated with each of these labor codes. So Section A, as we've heard, apportionment shall be based on causation, on the causation. Mr. Carrillo referred to that as non-industrial contributing causal factors of the overall permanent disability. Now, this is what relates to us as QMEs. It says by law, and this is the law is Labor Code Section 4663, it says that a physician, that's us, who prepares a report addressing the issue of permanent disability, in that report, shall address the issue of causation of the permanent disability. So, of course, there's no obligation to address apportionment when there is no permanent disability. And many of the evaluations that we do involve cases that don't involve permanent disability. We have cases that we determine are non-industrial injuries. We opine against AOE, COE. That type of report does not require an apportionment discussion. If we have an examinee who we opine is not permanent and stationary and requires additional medical treatment, and we're not providing an impairment or disability discussion, that report does not require a discussion of apportionment. But if you're preparing a report and you're opining for permanent impairment, you then must, by law, it says here shall, and shall is mandatory, you must then address the causation in a section of your report, and we're going to call that section of our report the apportionment section of the report. So when it says we shall address, the labor code then goes on to give us some instructions as to exactly how do we address it. So it says in the next 3 sections, in order for your report to be complete on the issue of permanent disability, the report must include an apportionment determination. Isn't that interesting? Your permanent impairment or permanent disability discussion is not complete unless you tell us what are the causes of that permanent disability. It's not complete. The apportionment discussion completes the disability discussion. Very, very interesting. So here's how you do it. Here's how you do it. And Mr. Corio already gave us the formula for this. You make your apportionment determination by finding what approximate, in highlight, approximate percentage was caused by the direct result of an industrial injury, AOE, COE, and what approximate percentage, Mr. Corio said it was referred to as twice, approximate was referenced twice, here it is, what approximate percentage was caused by other factors, both before and subsequent to the industrial injury, including prior industrial injuries. Now, a couple things to point out here, and this is fascinating. It's fascinating. I used to think that approximate percentages allowed me to use a range of percentages. In other words, I used to say some things in my reports like, in my opinion, approximately 60 to 70%. In other words, I would use a range because it was approximate. So we're allowed to use approximates. And I would use a range mostly to indicate that it was my opinion that the higher percentage, 50 to 60 or 60 to 70, I thought that a range would help me convey the idea that the greater portion or the lesser portion was either due to the injury or due to the other factors, depending on what I was arguing. But I learned that even though the law allows us to use approximate percentages, we have to provide an exact number. Okay, we have to provide a specific and exact number, but we buffer that number by putting the word approximate in front of the number. So you would say approximately 60% is due to the industrial injury and approximately 40% is due to other factors. So that's one interesting thing about these passages. The next interesting thing, and this is just fascinating, imagine this. It says, including prior industrial injuries. Now, notice, it does not say prior sports injuries. It does not say prior automobile accident injuries. It does not say prior slip and fall injuries. The language of the law is specific for prior industrial injuries. Why do you think that would be? Well, the reason that is because the legislators want us to give great consideration to examinees who are multiple injured employees who come back through the system and have multiple industrial injuries. And we're going to see in Labor Code Section 4664, 4664 also deals with prior industrial injuries. It's fascinating. So prior industrial injuries is one of the key things that you want to pursue in your interview with the examinee. You want to pursue prior industrial injuries before the current industrial injury. You also want to pursue industrial injuries subsequent to the current industrial injury that you're evaluating. Now, this is where you have to get good in the interview with your examinee. And I think I have a slide here. Yeah, here. So if you look at this, when you sit down to write your apportionment discussion within the body of your report, you're going to hope, you're going to wish that you have the data regarding prior industrial injuries. You're going to wish you have the data regarding other factors before the industrial injury. You're going to want to have the data about other factors after the industrial injury. How do you do that? How do you do that? You do that in the relevant medical history section of your report. This is where in the face-to-face interview with the examinee, you sit down with the examinee and you ask them specific questions. In this section, the relevant medical history section of your report, this is where you pursue prior injuries, settlements, descriptions from the medical records, supplemented by the claimant's description. All of that stuff goes here. So, for example, you would ask Mrs. Smith, prior industrial injuries. Have you ever had a prior industrial injury, Mrs. Smith? And take all the data about that prior industrial injury here. What about non-industrial injuries, Mrs. Jones? What about in college? What about in high school? Did you ever play sports? Did you ever have a slip and fall? When it comes time to write the apportionment section of your report on a Sunday afternoon when you're sitting down to do this thing, you're going to hope that you have the necessary data upon which to base your apportionment opinion. And this is where you obtain the data in this section of your report. What about after the industrial injury, Mrs. Jones? Did you ever have any other injury at work after you had the injury that I'm evaluating you for? No, I never had any. Fill out her answer right here. What about subsequent non-industrial injury? How often do we see this? We see this all the time. How many times have you had a case where the employee injured worker had a work injury on such and such a date, let's say January 1st, 2021, and then sometime thereafter that they had a car accident? I don't know about you, but I see that all the time. That's your subsequent non-industrial injuries. So you're going to want to get all the data that you need later when it comes time to write your apportionment argument. This is where you get the data upon which your opinion is going to be based. When we get to talking about our apportionment approximate percentages, one of the rules to qualify your opinion as substantial medical evidence is that your opinion must be based on relevant facts. Where do the relevant facts come from? They come from the relevant medical history. Isn't that interesting? So this is a key portion of your interview with the examinee, is to get the data upon which your apportionment argument is going to be based. Finally, good question to always ask, because sometimes examinees, as you know, they have a little bit of amnesia by the time they get to us. They have amnesia. They forget. So you can ask them, have you ever had injury to the same or similar body part, such as your lumbar spine, Mrs. Jones, that's now involved in this workers' compensation claim? And get their answer to that question so that you can have the data later when it comes time to write your report. Okay? So these are some of the other factors: prior injuries, subsequent injuries. Other factors, as Mr. Carrillo said, we're seeing that the potential list of things that constitute or can be defined as other factors is growing. The list is growing. I'm going to share with you a couple of them in a minute. So it says here, in the context of apportionment, other factors that may provide the basis for valid apportionment are typically non-industrial factors that contribute to the worker's permanent disability. These factors include pre-existing conditions, diseases, or disabilities that were present before the industrial injury occurred, as well as conditions or disabilities that arise after the industrial injury. Now, I don't know about you, but I'm sometimes not so great about developing the history as to what happened after the industrial injury, but it's something that we need to get better at, speaking for myself included. It says any non-industrial factor that contributes to the worker's permanent disability could potentially be considered as a basis for apportionment. This could include conditions such as diabetes, obesity, or other chronic health conditions that may affect the worker's ability to recover from the industrial injury. Isn't that interesting? Many of these pre-existing conditions block and prevent the examinee from recovering to a pre-injury condition. Isn't that interesting? You know, the purpose of medical treatment, the reason we pay for medical treatment for examinees to undergo medical treatment is so that the medical treatment will help them. Hopefully, the medical treatment helps an injured worker to recover to a pre-injury condition. That's what happens in our clinical practice, correct? We render treatment and patients recover to a pre-injury condition. If a patient does not recover to pre-injury condition, the question becomes, why? Why? Why did the injured worker not recover to pre-injury condition? And many times, it's these other factors that prevent and block the injured worker from recovering to a pre-injury condition, and the employer is not responsible for those other factors. Very fascinating. So you can ask yourself many times, why isn't this injured worker recovering? Why are they not better? The answer can largely be attributed to other factors. Other factors could also include lifestyle choices. Mr. Carrillo referred to poor dietary choices, genetic predispositions that may affect the injured worker's health and disability status. So let me give you some examples of other factors. So here's some of the other factors that were espoused in the Escobedo case. And I'm going to show you how we weave this into your apportionment discussion in the body of your report. So Escobedo talked about pre-existing disability, talked about disability caused by the natural progression of non-industrial pre-existing disease or conditions, talked about a post-injury disabling event. As I said, this is an area where my history is kind of weak. I don't really spend much time, and I don't know why. I need to focus more on establishing the history after the industrial injury. Pathology, asymptomatic prior conditions, retroactive prophylactic work restrictions, which pretty much doesn't apply to the work that we do now in 2023. And then Labor Code Section 4663 and 4664 both reference prior industrial injuries as an other factor. So these are some of the things that you're going to want to explore in your history and in your review of the medical records regarding your examinee. You're going to be looking for any of these potential apportionable other factors. So let me give you some examples. So if you notice here, these items, disability caused by the natural progression of pre-existing industrial disease, pathology, asymptomatic prior conditions, these are kind of like, I don't know, it seems to me like they're kind of all sort of the same thing. A pathology is kind of like an asymptomatic prior condition. The pathology could be either symptomatic or asymptomatic. So let's kind of take these three, the disability, the pathology, and asymptomatic, and let's look at some examples. So here's some examples that you might be familiar with. So I've put these all together in one grouping. Disability by natural progression, pathology, and asymptomatic prior conditions. Okay, so if you're a spinal evaluator, and I know many of you are, here's some conditions that we commonly encounter. We encounter examinees who have a lumbosacral transitional vertebra. We encounter examinees that have cervical rib. They have facet asymmetry, block vertebra, spinal stenosis. All of this stuff facet hypertrophy, okay? All of these anomalies, defects, and deformities that we've learned about and that we see in our clinical practice, we see these same things in our examinees. Well, isn't it interesting when an examinee comes in with a spinal injury, an industrial spinal injury, and diagnostic studies show, sure enough, sure enough, there's a lumbarized S1 spinal segment or a sacralized L5 spinal segment. In other words, they have a lumbosacral transitional vertebra. Well, the question becomes, in the absence of that lumbosacral transitional vertebra, would this examinee even have suffered injury in the first place, right? This is the concept of causation of injury, causation of injury. And if they did indeed suffer an industrial injury, even in the absence of that lumbosacral transitional vertebra, would not that examinee have recovered to a pre-injury condition, considering 24 visits of physical therapy, 24 visits of chiropractic treatment, 2 years of TTD? Would you expect that examinee to recover with an uncomplicated spinal injury? But it's these types of anomalies, degenerative changes, and defects that block the examinee and hinder the recovery of the examinee. And the employer is not responsible for the portion of the disability that's caused by these pre-existing diseases or conditions, by these pathologies, even if they were asymptomatic prior to the injury. What about the upper extremity? And we see these all the time. Examinee comes in and they have a wrist injury, a repetitive cumulative trauma type of injury to the wrist. From working on the assembly line, we take an x-ray, and sure enough, there's ulnar variance. There's ulnar variance. They have a long ulna bone contributing to ulnar impaction syndrome, and that's exactly the symptoms that they're complaining of. Ulnar impaction type of syndrome, symptoms, ulnar-sided wrist pain. So if that examinee fails to recover to pre-injury condition and goes on to have an impairment, the employer is not responsible for the portion of the impairment caused by the ulnar variance, caused by in the shoulder a downward sloping acromion, for those rotator cuff cases, for any of these other defects or deformities. Same with the lower extremity. We see these examinees. Imagine you have an examinee comes in and they're telling you about a knee injury that they've suffered. And you look at them and they have genu recurvatum deformity of the knee. They've got those knees that extend way back behind the center of mass of the body. Certainly that's going to predispose to injury, and it's also going to contribute to the permanent impairment when that examinee is permanent and stationary. How about a case where you have a chondromalacia case, right? Chondromalacia patella case. You take an x-ray and the examinee has a bipartite or a tripartite patella. Of course, that's going to contribute to the impairment. And that needs to be apportioned out because the employer is not responsible for the portion of the impairment caused by that particular condition. So this is just an example of this is, neuromusculoskeletal examples of the many, many different other factors that can contribute to the permanent impairment or permanent disability. These are all neuromusculoskeletal or internal medicine specialists. They can think of their own list of pre-existing conditions and pathologic conditions. Our psychiatric evaluators have their own list. And all of these conditions, this growing list of other factor conditions, need to be apportioned out. We need to take a hard look at these and ask ourselves, are these conditions contributing to the final permanent impairment? Okay? So that's 4663. Let's go on to 4664, and this is fascinating as well. This section of the law is new, by the way. We said that this was passed by Senate Bill 899, so this is new. It says, the employer shall only be liable for the percentage of permanent disability directly caused by the injury arising out of and occurring in the course of employment. Now, let me ask you, is that fair? Is that Is that fair? Is that how you would want it? I know all of you are employers, and if you had an injured worker, would you want to be responsible for more than what you're responsible for? I don't think you would. I think this is very fair, and this is new. Can you imagine that? Before 2004, this was not so. The employer was basically on the hook for the entirety of the disability, but now they're only liable for the portion that they're liable for. Now, you've seen this before, and we're going to spend some time on this. I have an example of this. This is fascinating. It says, if the applicant has received a prior award of permanent disability, so it's a prior permanent disability award, it shall be conclusively presumed that the prior disability exists at the time of any later, subsequent means later, of any later injury. Okay? So let me ask you, if the prior permanent disability exists, and basically this law says it exists and it persists forever, at least administratively, it exists and persists forever. What is it about the permanent disability that exists and persists forever? What about it? What about it persists? Is it just the numeric number of the permanent disability rating? This guy was rated at 10% permanent disability in 2010. Is it just the number 10% that exists and persists forever? Well, yes, it is the number. But what else? What else exists and persists forever are all of the factors of disability that went into this permanent disability rating at the time. All of that stuff persists and exists forever, at least administratively. In other words, before the passage of this law, which is new, it used to be argued that the permanent disability went away. Injured workers used to be able to argue what's referred to as a medical rehabilitation. And I'm sure you've heard these arguments before. Injured worker says, yeah, after I got that permanent disability award and, after I cashed the check, and after that, I started going to the chiropractor and I changed my diet and I lost 30 pounds. And you know what? Since then, my back has been fine. I had no problem whatsoever. And sure enough, you look at the medical records and there's no sign of any treatment for the prior injury. There's no chiropractic visits. There's no medical visits. There's no lost time from work. The injured worker may actually have had a medical rehabilitation. And they used to argue that before the passage of this, and they still argue it now. But by law, 4664 says, if you got a permanent disability, it exists and persists forever. What does that mean? That means when they had their permanent disability award at the time, all of the factors of disability that contributed to that award persist. The pain persists. The lost range of motion persists. The positive objective findings persists. The limitations and activities of daily living upon which the prior disability award was based exists and persists forever. Isn't that fascinating?
Can I just, you're touching on one of the more complicated areas of 4664 as opposed to 4663. So just a cautionary note, I have a slide in the PowerPoint presentation, slide 6, that deals with it. There's an entire chapter in my case law outline from chapter 12, deals with 4664. So you have to be very, very careful here, especially on petitions to reopen for new and further disability about prior awards. A lot of this only applies to, about rehabilitation, not only to the conclusive presumption aspects of apportionment. And you have to be careful about distinguishing 4064 from 4663, because again, this A, B, and C are basically designed to see in what particular situations and circumstances can a defendant get, credit for a prior award to the same body part, condition, or system injury. So it's a very strict kind of thing. And all I need to say on it very quickly is that you have to have both the award, you have to show that there was a prior award, not a CNR, and that you have to show overlapping disability. And that's the problem. The pitfall for the defendants in this particular area about proving up the conclusive presumption of a prior award is they have to prove the award, and secondly, they have to prove up that the disability from the prior award and the current injury, the disability from the current injury to that same body part or condition overlaps. And so that becomes a very complicated area, both medically and legally, the overlapping issue. And you'll see many of the cases in the outline chapter 12, where the defendant has failed to prove up the overlapping component and they don't get it. But here's what is important, and I'm pretty sure that Dr. Carpenter is not going to touch on this. You can get, even though you fail as a defendant, to obtain 4664 apportionment for a prior award. That prior injury that was the basis for that award can still be a basis for apportionment under 4663 separately and independently. There are a number of cases that I have in the outline, and I have right over here, that show that in certain cases, the defendant was able to get 4663 and 4664 apportionment in the same case. It's not double dipping. It's just because they met all the requirements of both of the statutes. The other thing on petition to reopen for new and further, it touches on what Dr. Carpenter is saying. When you say that all of these things exist in perpetuity of this, the pain and all, and I'm not sure that what happens is that for purposes of a petition to reopen for new and further disability, what is assumed is you can't assume that you can't go behind the award. In other words, there's some defendants who've argued that on a 46% award, that where there was 22% whatever non-industrial disability, that they just get to carry that 22% over to the new and further disability, and they do not. You have to, if you're doing apportionment on a petition to reopen for new and further, and you're a medical legal evaluator, you take the date of the award up to the date of generally the MMI evaluation, and you determine whether or not what percentage approximately that condition or whatever is a contributing cause of the new and further disability. You can see it was to the back, and there was apportionment to the back based on non-industrial conditions to the actual award. The question is, in the intervening 6, 7, 10 years, whatever it happens to be, has that same condition, degenerative condition of the lumbar spine, progressed to the degree that it's a contributing cause of the new and further disability? Those are separate questions. Anyway, sorry, that's a very complicated area.
Well, so correct me if I'm wrong. So knowing this, knowing that, administratively this persists and exists, our concern as qualified medical evaluator in these types of cases is for the worsening. It's for the worsening. So the injured worker, so in order to qualify for additional permanent impairment above and beyond that which already existed, the injured worker has to demonstrate worsening. So when the injured worker comes in and they says, I have pain, we know that according to this, they already had pain. When they say my back is stiff, we know that there's a prior QME medical legal report that describes and documents stiffness. We already know that they had stiffness. Tell me, how are you stiffer? How are you worse? I know you have a bad back. You already had a bad back. It's documented. How is it worse? Our concern becomes for the worsening. So if you can spot this thing in advance, you have an examinee who has a prior permanent disability in advance, then you know that your investigation is for the worsening. Okay? So under 4664, an injured worker cannot argue for a medical rehabilitation. Under 4663, they can argue for a medical rehabilitation. And many times people do rehabilitate themselves. But under 4664, that permanent disability is presumed to exist and persist. So in conclusion, both of these, 4663 and 4664, interestingly, they both address prior industrial injury. So that tells us that the legislature's intent was for us to be very inquisitive as to a history of prior industrial injury. And as Mr. Corrillo said, the burden of establishing apportionment to other factors falls upon the defendant. So many times injured workers, they have quite a bit of amnesia about their prior industrial injuries because they know that the burden is upon the defendant. So they might not be forthcoming or very recollective, if that's even a word, recollective of their history of prior industrial injuries. So that's where we need to dig for a history of prior industrial injury. Okay, so let's talk about now that we have some of these principles, let's talk about how to put this together in the apportionment section of our report. So we're going to talk about a couple of important issues related to substantial medical evidence. So according to Escobedo, our apportionment determination must detail the exact nature of the apportionable disability. So this is very interesting. Before you can discuss apportionment, you have to be very, very clear on exactly what it is you're apportioning. Sometimes I get calls from qualified medical evaluators and they jump right into their apportionment questions. And I have to stop them and say, hold on. So tell me what is the impairment? First of all, get clear on the impairment, and then you can handle the apportionment. Next, you must set forth the basis for the opinion. What is the opinion? What opinion does this refer to? The opinion refers to the opinion of your apportionment percentages. That's the opinion that this refers to. You must tell us how it was that you arrived at these particular percentages. That way the board can determine whether you're apportioning under correct legal principles. So you have to be clear on the impairment first, and then you must tell us how you arrived at your apportionment percentages. Be clear and set forth the basis for the opinion. This is the whole concept of substantial medical evidence. Now, I know you've heard about this term, substantial medical evidence. It has sort of this mysterious sort of mystique out there. Let me clarify this for you, and let me show you how you can use substantial medical evidence as a tool that will help you arrive at the perfectly accurate, perfectly correct apportionment percentages every single time. So I have here a list of historic cases that describe for us what constitutes substantial medical evidence. So let's just go through a couple of these one by one. First one is the Garza case. Garza case says, and I have something blocking me here. I can't quite read it, so I'll read it from here. It says, any award, and Judge Corrillo will confirm this, any award, any order or decision of the board must be supported by substantial evidence in light of the entire record. So the board can only resolve cases when those cases are supported, when the opinions of those cases are supported by substantial evidence. It's the standard, it's the level, it's the requirement required by the board. So Zemke says an opinion that does not disclose its underlying basis and gives a bare legal conclusion does not constitute substantial medical evidence. So with regards to our apportionment determination, what would be the bare legal conclusion? The bare legal conclusion would be something like the following, and I see these in reports all the time. It says, in my opinion, 80% of the impairment is due to the industrial injury and 20% is due to other factors. That's the bare legal conclusion. That's the conclusion. But a conclusion that does not disclose its underlying basis does not constitute substantial medical evidence. So if we know that, we now know that our opinion has to contain at least two components. It has to have, number one, it has to have the legal conclusion, and that it has to also have its underlying basis. West said an expert opinion is no stronger than the facts upon which it is based. So we're developing our formula now. We now know that our basis, our underlying basis, must be based on facts. Interesting. A mere legal conclusion does not form a basis for a finding. And then finally, Bassett, and this is the great one here, it said the chief value of an expert testimony, experts, and that's us, we're medical experts, rests upon the material from which his or her opinion is fashioned and the reasoning by which he or she progresses from the material to the conclusion, and it does not lie in the mere expression of the conclusion. And here's the symbols clashing together now. Thus, the opinion of the expert is no better than the reasons upon which it's based. See, it's interesting. The parties are a lot like kids. You know, when you tell something to your kids always come back at you and they say, well, why? Why, Dad? Why do you say that? Why is that, Dad? And the parties are the same. Anytime you provide a legal conclusion, you have to tell them why. Why? Why did you come up with that apportionment approximate percentages? You must give them the reasons. So we're starting to develop our formula here. We have to have an underlying basis. That basis has to be based on facts. And we must provide the reasons why we opine the way that we do. So let's start putting it together. So here's a couple examples. Here's a couple examples of bare conclusions. These are not legal conclusions, but these are just some examples to show you. Here's the conclusion, the conclusory portion of an opinion. The team played poorly. Now, how can we make this opinion a substantial opinion? You know, it's interesting. The word substantial is kind of a takeoff on the word substance. How can we add some substance to this opinion? How about this opinion? The team played poorly because, and here comes the basis for the opinion, because they had a shooting percentage of just X percent, they committed 20 turnovers, and they had significantly higher than their average of 12. You see how these facts, these are facts, add substance to the opinion? How about this one? The movie was terrible. That's called the conclusory portion of the opinion. Now we're going to add some substance to it. The movie was terrible because the plot was unpredictable, the characters were one-dimensional, the effects were subpar, and the whole movie received a rating of just 2 out of 10 points by the film critics at the New York Times. Here is the underlying basis and the facts which support that opinion. So with regards to your apportionment opinion, 80% is due to the industrial injury and 20% due to other factors. How could you make that opinion more substantial? Let me show you the formula. So here's the formula. First of all, the opinion must be predicated on reasonable medical probability. First of all, how would you do that? How would you predicate your opinion on reasonable medical probability? I'll show you how to do that in just a minute. Number 2, an opinion is not substantial medical evidence if it's based on facts no longer germane. This is right from the Escobedo case. Now, what is the opposite of facts that are no longer germane? The opposite of that is facts that are still germane, facts that are germane. I like to refer to them as relevant facts. We'll talk about relevant facts. So your opinion must be based on relevant facts. Number two, an opinion is not substantial evidence if it's based on inadequate medical histories or exams, if it's based on incorrect legal theories, if it's based on surmise, speculation, conjecture, or guess. And further, it's not substantial if it does not set forth the reason behind the opinion or the conclusion. So I want to fast forward now to our template and show you how to construct this within the body of the report. We're a little short on time, so I want to get right to it. Okay? So we're going to take all of those criteria from the Escobedo case and all of those other cases as well, Garza, West, etc., and put them together in the apportionment section of our report. So here is the apportionment section of the report. This is right from your template. Here's the topic heading, apportionment. So you put here all of the cover letter questions, because we're required by law, CCR 35.5C right here is where we're going to put the attorney's questions. And then we're going to go ahead and answer those apportionment questions in this particular format. This is how you hit all of those high notes required so far. So you'll fill in here your first body part. Let's say, for example, it's the lumbar spine, okay? And then you give us your first impairment. Now, sometimes you'll only have one impairment, like a DRE2 is one impairment, okay? But if you're talking about a shoulder, you might have a couple of different impairments. So here's where you tell us about the first impairment. And Mr. Carrillo might have something to say about this when we get to comments. So you put in your first impairment. You tell us now the conclusory portion of the opinion right here. Here's where you tell us the exact nature of the impairment or disability. My impairment rating, let's here say, is 8% whole person impairment due to muscle guarding under the DRE category 2, something like this. I'm just making this up, okay? You give us the exact nature of the apportionable disability. There it is. Then you tell us first under 4663, and then in a minute you'll tell us under 4664, but first you'll handle 4663, and you give us the conclusion. It says, in my opinion, and within reasonable medical probability, 75% of the permanent impairment is due to the January 1st, 2022 industrial injury, and 25% of the permanent impairment is due to other contributing causal factors. Now, in this case, the other contributing causal factors include the following. Here's where you tell the parties. You show the parties your cards. You show your hand. You tell them, here's the causal factors I'm apportioning to. And here is a list. These are all the contributing causal factors from Escobedo. Here's some other ones that you can consider. And this is not a complete list. As Mr. Carrillo said, this list is basically limited only by your imagination. You can add obesity, diabetes, flat foot, spina bifida, whatever. Okay, these are just for you to choose from. Now, you have a choice. You can either give a description here, does not apply. If there's no pre-existing disability, you can say it does not apply to Mr. Jones. Or you could just delete the whole thing. You could either just delete this if it doesn't apply, or you could show us that you considered it by filling it out right here. Does not apply to Mr. Jones. Okay.
Dr. Carpenter, I just want to remind you, you got 2 minutes left.
Okay. So we're going through this, and you just tell us what are the contributing causal factors. Then, once you show your cards, now you're going to start telling us the reasons for this conclusion. And this conclusion refers to your conclusion here of 75-25. 25. That's the conclusion. So you're going to tell us the reasons for this conclusion of 75-25, and then you're going to tell us it's based on reasonable medical probability. Then you're going to give us the pertinent or relevant facts that support your approximate percentages. And what are the facts that are relevant to the approximate percentages? What are the facts? Well, maybe some facts related to the mechanism of injury. Maybe some facts referring to the diagnostic studies and severity factors. This is what Mr. Corrillo referred to. Maybe you'll talk about facts about the medical care. Maybe you'll talk about facts about pre-existing conditions. In other words, here is where you show your cards and give us the facts upon which your approximate percentages are going to be based. Confirm for us that you did an adequate history and an adequate exam. You give the how and why reasoning. And here is where you pull the whole argument together. You give us the whole reason as to how you came up with 75-25. Up here, you're just laying the groundwork for your 75-25. And then down here, you bring it all together. Confirm for us that none of this is based on speculation, conjecture, or guess. And if there's no prior award of permanent disability, then you're done. If there is a prior award of permanent disability, then you can go through this algorithm under 4664, and I will provide this for you. In fact, I already did include this for you in your handout materials. So this is an algorithm that you can use. Okay, almost done. If you have a second impairment of that same body part, then you would go through the argument here in this particular section of the report and tell us about the second impairment. If you have another body part involved, that would go here and you would just repeat the same procedure above. So this is a template that you can use, and I have another handout for you that gives you case examples that shows this template in operation. Okay, so I wish we had another 30 minutes. I got a lot to say about this, but we'll conclude now, and I'll take any questions that anyone may have.
There are a couple questions that came up. One, Dr. Fishman wants to get my PowerPoint. Dr. Carpenter, if you can send it to him or anybody else who wants it.
Okay.
And there was, I think the attorney, I forget his name, made a comment also that safety members, correctional officers are safety members for purposes of the anti-attribution thing that gave the code section.
Okay, very well.
And one more thing, those of you, because Dr. Carpenter mentioned age as one contributing causal factor, you have to be very careful with that. So I would caution you to read my case outline, Chapter 2, Age, Gender, and Genetics. Related to those, sometimes the way you might pose some of those would not be acceptable, especially about age and gender and genetics. I'm a big critic of the Rice case by the Court of Appeal, and the opposite attorneys love me for that. I don't think you can apportion directly to genetics. You can only apportion to the pathology that may have a genetic basis or a congenital basis. You cannot apportion directly to genetics. That's my theory on that. And that's based on the Rice case.